Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. This is the January 12th, 2026 sitting of the Appeals Court. I'm Associate Justice Sabita Singh. With me here is Justice Rachel Hershfang, and to this side we have Justice Chauncey Wood. We will be your panel for today's session. I believe all the parties are aware that there's 15 minutes per side unless other arrangements have been made previously. At this point, I'll call the first case, Commonwealth versus Arthur BUBANAS, 25P 228. This is partially impounded, just reminding the parties.
All right, good morning. May it please the court, I'm Attorney Sarah Unger, here for Mr. Arthur BUBANAS, the defendant appellant. In this case, as you know, my client was convicted of assault and battery of a disabled person causing bodily injury. And one of the elements that the Commonwealth was bound to prove was the disability of the victim. To that end, the trial court allowed the Commonwealth to present, over defense counsel's objection, testimony, as well as statements within the medical records that ostensibly evidenced the victim's intellectual disability, but in reality were irrelevant, inflammatory, and served only to unfairly exploit the jury's sympathies. With that in mind, I'd like to focus on my second and third arguments in my brief, beginning with the admission of the contested statements in the medical records. This was an abuse of discretion. The thing that we focus on when admitting medical records, the thing that gives rise to the presumption of reliability is, did a doctor or nurse or other licensed professional say these things? Is there a totem pole hearsay? In other words, are these trustworthy? And the presumption is usually yes, because these statements were made for the purpose of diagnosis or treatment. And in this case, there's no such indication. These are not reliable statements. They're largely unattributed. It's hard to say who wrote them. I know a name appears next to on the same page as some of the statements. It's unclear what level of medical professional this is. It doesn't appear to be a doctor because other names appear with MD next to them. It doesn't appear to be a nurse. Basically, we don't know who this person is, and we also don't know the source of the statements and how many layers of hearsay preceded their entry into the records.
Isn't that, though, also always the case in these types of entries? You can often not identify the specific person who got that item into the record, right?
Often there is the entry and you see a doctor's name or a nurse's name, and either way it will be attributed to a source. And here that's not true. You need some indication that it was indicated by something that you can rely on. Otherwise, the presumption of reliability just doesn't apply. And Bushi is a useful guide in gauging this. And although in Bushi the records in question were admitted under Section 79, here it was 79G, so a little bit different. The same considerations apply. Basically, was the record of the type contemplated by the statute? Yes. Was the information germane to the patient's treatment or medical history? Well, I'd like to say yes, but here's the thing. While I am not contesting that intellectual disability can be germane to treatment or diagnosis, or is in this case, this is if the intellectual disability is an actual diagnosis from a physician, or if it is actually reliable family history from a close relative. The cases also allow for that, and there's just no indication who it's from.
So let's say a man walks into an emergency room. I almost said a bar because that sounds much better, but a man walks into an emergency room. Actually, he's crutches in because one of his legs is broken. He's not there for his broken leg. He's there because the foot on his broken leg has started paining him in some way. And as part of the treatment notes, it says, patient presents with broken leg. It's relevant to the treatment. It's not being diagnosed. He's already on crutches. He's clearly seen someone about it. Is that admissible or not?
That, I would say, would be admissible, Your Honor, assuming that this was entered by a qualified medical professional or attributed to someone else covered by the statute. Because when that statement doesn't come from someone covered by the statute, the presumption of reliability just simply isn't there.
So how is that different from what we have here?
Here, these are largely unattributed statements, or where it says the name, there's no indication of who that is. There's no indication of...
You mean, so RA 331, performed by Alan Antos.
Yes, Your Honor.
Developmentally delayed patient presents with mother. It's actually not mother. But, so you're saying, I can't remember, put my finger on the site, but I think your opponent will say that we do know who Alan is, a nurse, a registered nurse. Are you saying the evidence is that we don't know who Alan Antos is?
So, yes, Your Honor, I looked at the record and I don't see an indication of his position or profession. For all we know, from what I saw on the record, this could be a social worker, a volunteer, an intake
triage.
professional.
It's the top of that page says ED, which I take to mean emergency department, triage, entered on, date, performed on by Antos Allen.
Yes, Your Honor.
Is it reasonable for us to think that someone who is not a medical professional is doing triage in the emergency room?
It is reasonable. I think we cannot conclude that the Commonwealth has met its burden of proof to show admissibility because you do have intake professionals working in hospitals that aren't necessarily RNs, that aren't MDs, you do have volunteers, you do have social workers helping with intake. And so without any indication of who this is, we cannot assume, we can't guess. And I think this is what the trial judge did here. He guessed, and while it is within the trial judge's discretion to weigh the facts and determine admissibility, it is not within a trial judge's discretion to fill in gaps and make assumptions, and based on those assumptions, weigh whether or not something is admissible.
Let's assume for the moment that I agree with you that this material should not have been admitted. What is the prejudice to your client?
So without this was the strongest and the most harmful evidence of mental disability because, yes, the Commonwealth had two other things going for it at trial, basically. The testimony of the sisters and the testimony of Dr. Milosavljevic. And
Wait, and can I pause you on the sister or sisters? One of those sisters, at least, was in fact, she testified, his guardian, right? His legal guardian?
she testified that she had been appointed, that she was his guardian, but there was no evidence as to the parameters or duration or bounds of this guardianship, if that's what it was. This is another issue that is addressed in my brief, because basically without an indication as to why guardianship was granted, or the parameters or bounds of this doesn't really tell us much, because guardianship can be granted for a number of reasons, besides just mental disability. And the parameters under which guardianship is granted, that's separate from, that's not exactly coextensive with mental disability. There's some overlap, but...
I interrupted you. You were answering Justice Hershfang's question about harmless error.
Yes, Your Honor. So there were the two other things going, the sisters, their testimony, and the doctors. And as far as the sisters' testimony, it's true. They established that the victim had limitations, that he received help from them. But this was hardly enough on its own to show his mental disability beyond a reasonable doubt, because if you look at the statute, the jury instructions, which were the same, the Commonwealth was bound to prove that the victim was unable to provide for the day-to-day activities and his own daily needs due to this mental disability. And so while the sisters, their testimony did establish that they helped him with day-to-day activities, although I'd point out that the testimony of the younger sister who lived with the victim more recently, and his own testimony seemed to establish that a lot of the day-to-day he was fine without their assistance. That wasn't alone to show that there was a mental disability that caused him to need help with these day-to-day living activities. And if you look at Dr. Milosavljevich's testimony, trial counsel did a very good job of addressing this on cross, not to mention the fact of the stipulation that was entered. Between those two things, it was revealed that this wasn't even this wasn't a diagnosis. He didn't perform the tests necessary for a diagnosis. He testified to this. It wasn't even his area. Oh, do you use the DSM-5? No, that's not my specialty. Did you perform this test or this test? No, not really. No, I didn't perform that. I based my, idea of this on the exam and family history. Oh, so history, so you looked at his other medical records. No, I didn't look at any medical records. I didn't look at anything else.
Can I bring you back to the record RA 3, 25, and 26? Those both make reference. One is active problem list, mild mental retardation, modified on 5/24/19. I think your opponent is going to point out that date is important. This is a medical history, and I think the case law indicates, correct me if I'm wrong, that medical history is precisely the sort of thing that medical records can be deemed reliable for, and it's non-hearsay. It's not an exception, it's non-hearsay because of the reliability. And then the next page, past medical history, mild mental retardation. So it seems that this is in his medical record, especially the first one. It seems that it was entered on May 24, 2019, or modified, and it seems to be tracking in his medical records. Why is that not precisely what the medical records statute is designed to address?
Because putting the heading of medical history over something, that's not alone enough to show that this is reliable medical history, because then you could just put this over anything. Medical history. Right,
no, but it seems to me that the hospital is not willy-nilly putting medical history anywhere. They themselves, they have the whole reason for the statute and for the reason it's deemed reliable is that we know medical facilities have an important job and that they don't just put medical history anywhere. This is created by the hospital. What possible justification would they have for putting medical history just anywhere and writing whatever they want? It's the opposite. They have to be reliable in order to provide care.
But here's what's missing. There is no attribution. It doesn't say medical history. Sister reported this. Medical history was previously examined for a mental disability on this date. It just says medical history and then an unattributed statement. So yes, we can and should rely on medical history, but not if it's just anonymous, not if there's nothing else there. Doctors enter references to past records or past physicians' opinions all the time. And in this case, we should not rely on that because it is unattributed and there's nothing else.
So if you're going to rely on something in the medical history, the Commonwealth is required to go back to submit the original documentation, the original medical record where that appeared.
I'm not arguing that, Your Honor, but I'm arguing that if there is no indication of where that statement or where that prognosis or diagnosis or whatever came from, if it's completely unattributed to a previous medical professional or someone under the aegis of Section 7979G, then we can't necessarily trust it.
I think earlier you had said it's not attributed to anyone. If it was attributed to a family member, would that be acceptable? Family members giving medical history.
If it is attributed to a person with whom he has a close relationship, then yes, that is covered by the statute. I don't know if we can assume that that is any family member, but yes, Your Honor, the cases say that if it's a close family member, someone with an intimate relationship that you assume is going to know their medical needs and history, then yes, I agree. And I'll just quickly move on to my third argument, the prejudicial comments about the victim's limitations. And in this case, they were ostensibly about the victim's intellectual limitations, but really they were just inflammatory and had no real bearing.
You admit that that's an element of the crime, that the Commonwealth had to prove that he had an intellectual disability.
Yes, Your Honor, and if they were actually reliably indicative of that, I would say they were admissible. But when a witness like the officer did testifies, oh, this is the way I talked to the victim, that has no bearing on the victim's limitations. And none of the cases.
Compared to his sister's testimony, that seems, I mean, if we're just talking about the amount of sympathy it engenders, the sister's testimony, it seems to me, is much more, well, comprehensive in fleshing out, in human terms, the intellectual disability, as opposed to the police officer's fleeting, I would say, reference to how they talked to him.
While their testimony, compared in length to the sister's testimony, it was brief, it still added to the weight of the Commonwealth's evidence and added to the prejudicial force. So if there are no further questions, then I'll rest on that. Thank you. All right, thank you.
Thank you very much.
May it please the Court, Bennett Dembski, law student at Boston College for the Commonwealth. I'm joined by Assistant District Attorney Casey Sylvia. This Court should affirm the defendant's conviction. I'll start with the medical records issue that the defense just raised. So I want to just quickly break this down and look at the two statements one by one. The first statement comes from the victim's primary care records from when he went to the doctor after this attack took place. And here, as Justice Wood pointed out, the statement is of a diagnosis. It's listed with a workup date of 2019 in past medical history, which suggests that at some point a doctor examined the victim, diagnosed him, and wrote that down in the medical records. That's why it's there. The second statement comes from the hospital record. It's in the intake form. And in that case, one of two things is true. Either it was written down by the person who looked at the victim and wrote on the intake form. And there, it's not a guess, but a reasonable inference, a fair inference, to assume that the person writing that down, Alan Antos, was a registered nurse or some kind of medical professional. Or it was a statement said by the victim's sister, who was there with the victim at the hospital that night, and who told whoever was writing on that form, Mr. Antos, what was written down in the statement. That would be a statement made for purposes of medical treatment or diagnosis. And Justice Hershfang, to your point earlier, it would be for treatment because it would have been important for the hospital to know, the victim was coming in presenting with head injuries from the attack. It would have been important for the hospital to know at that point, whether or not, ways that the victim was presenting did or did not come from the attack or were a pre-existing condition. But more broadly, the reason that 79G sweeps so broadly is that it's a waste of time for everybody in the medical system and for everybody in the court system to go and track down every single person who writes anything down in a medical record. And if we adopted the defendant's position here, if we said, we need the report from 2019 where this diagnosis was made, we need Mr. Antos to come in and testify in order to get this, then we'd waste a lot of time. And the early cases from after this statute was passed make it very clear that that's why the statute sweeps very broadly. Even if you find that these two statements in the medical records were admitted in error, the error was not prejudicial. The Commonwealth here had to prove that the victim had a long-term mental impairment that restricted his ability to provide for his own care. And, defendant just pointed out that these two statements were our best evidence. They were not our best evidence that the victim had a long-term mental impairment. These were two statements buried in pages of medical records that were handed to the jury. Our best evidence was a diagnosis from a neurologist. It was a diagnosis. There was some back and forth on cross-examination about whether it was a presumptive diagnosis, about whether genetic testing could have confirmed the diagnosis, or a meeting with a psychotherapist could have reached a different kind of diagnosis. But here it was a diagnosis. There was testimony from the victim's sister that the victim needed help with daily tasks. And ultimately, the victim testified too. And the jury was able to look at the victim and assess the way he was responding to questions, and they were able ultimately to make their own determination.
I can't remember from your brief, on that last point, let's just assume hypothetically that all they had was the victim's testimony. Is there case law that a jury is competent to, in this context, make a determination that the victim is intellectually disabled?
So I'm not aware of any one case where the only evidence of a long-term mental impairment was just the victim's testimony.
And I'm not suggesting that is this case. I'm just interested.
No,
Yeah.
I'm not aware of a case where it would say that, but we don't have that situation here because that was just one thing that the jury got to consider. The testimony, again, testimony from two sisters about the victim's limitations in the ordinary course of daily life, and of course, the diagnosis from the neurologist who took the stand and testified. These two statements were not what this turned on when the jury made their determination that the Commonwealth had proved beyond a reasonable doubt that the victim had a long-term mental impairment. If the panel has no more questions on the medical records issue, I'll move now to that issue about commentary from lay witnesses about their observations of the victim. So here, the trial judge actually took great care to sanitize the record and make sure that witnesses weren't coming to conclusions about the victim's mental condition. They testified only to facts observed and their own actions in terms of how they interacted with the victim. In terms of the sister's testimony that she was his guardian, the case defendant cites to say that shouldn't have been allowed in here is an apposite. That was a case about a guardianship document being entered improperly because the Commonwealth hadn't met certain statutory authentication requirements. That's not what happened here. The victim's sister was just testifying that she was his guardian in the context of explaining why it was that she was helping him with, certain ordinary tasks in the course of the victim's daily life. But even if you find that the one comment by the officer that he spoke slower and clearer when he interacted with the victim, even if you find that the one line about the guardianship was admitted in error, again, this wasn't what this turned on. This was not what the jury was considering when they were back in that deliberation room making the determination that the victim had a long-term mental impairment. We had the diagnosis from the neurologist. We had testimony from the sister that wasn't challenged about the victim's limitations in the ordinary course of daily life, and of course, the victim's testimony himself. If there are no further questions about that testimony and that issue, I want to just briefly address, I know the defense didn't talk about it, but I want to briefly address the issue of identification on the video. So again, the standard there is abuse of discretion. This court reviews for prejudicial error. And here the judge watched the video, and he exercised his discretion to determine that the jury could use help with an identification. It wasn't so unmistakably clear that anybody would be able to identify the defendant, but it also wasn't so hopelessly obscure that nobody would have been able to figure out who it was. So the judge made the determination the jury could use some help, and the witness who made the identification had special familiarity with the defendant. And one point that isn't developed as much in my brief as probably it should be that I just want to draw your attention to here is that the judge conducted a fulsome voir dire of the witness who made the identification before he allowed the witness to come in front of the jury. And there, the identifying witness testified that he had additional familiarity with the defendant that wasn't social. When he was a police officer, he was called to a bar often that the defendant was working as a bartender at. He had been called to the defendant's house multiple times, and he testified he had interacted in all contexts with the defendant probably 20, 25 times over the course of however long he'd known him. And so while the judge didn't allow that stuff about police business to come in front of the jury, that was something that the judge considered when determining that the witness had enough familiarity to make the identification.
The defendant argues that part of the error in admitting this identification evidence was admitting it in the context of the officer testifying as an officer, not necessarily testifying as to his familiarity with the defendant as an officer, but that it was prejudicial to the defendant and, not best practice under the cases for the officer to present as a police officer and make this ID. What do you say to that?
So the cases are clear about this. And of course, Justice Hershfang, you're right. It would have been better practice for the witness not to identify himself as a police officer. But the case the defendant relies on to make that point is pleas. And in pleas, well, the court does say it would have been better practice for the witness not to identify himself as a police officer. They still decline to reverse. The court still says because the basis for the identification was social in nature, because what the jury heard was that the identifying witness had an acquaintanceship that was social with the defendant he was identifying, that a reversal wouldn't be warranted there, that any prejudice to the defendant because the witness, when they first got on the stand said, my occupation as a police officer isn't enough to reverse.
And in the circumstances of this case, wasn't the officer also the arresting officer?
Yes, but I just want to make clear that this officer, Lieutenant Murray, who made the identification, wasn't the one conducting the investigation. So somebody else was conducting the investigation. At some point, Lieutenant Murray was brought in to watch the video. He identified the defendant in the video. At that point, he went with another officer to the defendant's home and was one of the officers who arrested the defendant at that point.
And his familiarity, social familiarity, was limited to, as I recall from the record, that the jury heard was baseball umpiring from 2002 to 2011, and I think he testified about 10 or a dozen conversations over that 10-year period, which preceded this date of arrest by 10 years. Am I getting my facts right?
I think it might have been until 2014 that the Little League was happening. I can check and get
That's
back
okay.
to you.
I'll go back and check.
Okay.
But my point, I guess my point still holds. It had been several years since they had conversations in the Little League context.
Sure. So it had been several years since they'd had conversations in the Little League context, but I do want to point out that their interaction in the Little League context wasn't fleeting. The identifying witness was the coach of his kid's team. The defendant was the umpire. As anyone who's ever watched Little League baseball knows, the coaches have to talk to the umpire before the games, after the games. That was testified to. They got into it during the games. And he had additional familiarity. I think he testified that the last time he had seen the defendant was a few years ago. Again, that didn't come in front of the jury because it was related to police business.
Right.
But he, it wasn't like the last time he saw this guy was 10 years before. Even if that was the last time he'd seen the defendant, it still probably would have been okay for him to make the identification. He testified that the defendant's appearance had not changed much, that while he was a little grayer and maybe a little bit heavier, fundamentally he still looked like the same person that he once knew. And the case law is clear that the special familiarity standard, the court gets to exercise its discretion. And in this case, the trial judge listened to the testimony on voir dire and determined that the witness had enough familiarity to make the identification. Even if you find that was admitted in error, again, it wasn't prejudicial. The Commonwealth introduced strong evidence against the defendant, including an admission by the defendant to an employee at the bar right after the attack happened that, quote, "we just whacked this guy." One thing that cases point out is that when the judge gives a model jury instruction, the model jury instruction on eyewitness identification, prejudice is mitigated, and here the judge did do that. At the close of, after closing arguments, the judge, pointed out to the jury that ultimately it was up to them to determine who they saw on that video. And again, to the point I was making earlier, while it would have been better practice for him not to identify himself as a police officer because the basis for the identification was an acquaintanceship that was social in nature, it's not enough to reverse. If the panel has no more questions on the identification issue, the Commonwealth rests on its brief.
Thank you. Thank you. Very nice job. The matter is submitted. The next case is Commonwealth versus Elijah Finch, 25P189. And again, I'll remind counsel and all parties that this is also a partially impounded matter.
Good morning, Your Honors, and may it please the Court. My name is Ashley McCormick, and I represent Mr. Finch on this appeal.
Can you bring the microphone?
Sure thing. Is this better, Your Honor? The sole issue presented on this appeal is whether the Court erred in finding Mr. Finch in violation of his probation. And I think that can be further delineated into whether or not there was a full and complete court order for probation that was in effect at 12:59 p.m. on the day of his violation, and whether the defendant had adequate notice of it. To begin that analysis, I want to be very clear about what the record was that the violation judge had. Number one, what was admitted was a photograph of the defendant, which upon cross-examination or testimony of the probation officer who handled the hearing, he was unable to state at what time of day this photograph had been taken or in what context it had been taken. The second documents we have are the order of probation and a document we kind of colloquially call it in the district court, the probation contract. Similarly, these two documents, they are issued as both the initial plea charges and then an order with respect to the charges that happen after a bench trial. These documents have no date stamp, or no time stamp, I should say, which is obviously relevant here. So then the last piece of evidence certainly would be the transcript of the underlying colloquy. And digging into that, or actually before I go there, I would highlight the defendant's board of probation record was not offered by the Commonwealth at the violation hearing. I know it is in the Commonwealth's brief here. Neither were the green sheets. They were not substantive evidence before the court at the violation hearing. So I would ask that they not be considered in the court's analysis on this appeal. Standing with the trial court transcript of the plea hearing, I do think it's particularly illuminating. Number one, it paints the morning of a bench trial. Mr. Finch goes before the court just after 12:30 as the lunch recess is quickly approaching. He enters a fast colloquy before the court, and then it parlays right into a jury waiver. And the only order that the court really issues at that point is to come back at 2 p.m. There's no instruction by the judge, by probation, to meet with a probation officer. There's no discussion with the judge and the probation department. Is this administrative? Is this supervised probation? What are the court fines and fees that may be applicable? Are there any special conditions? There's no oral conversation about those terms whatsoever. The judge never issues the word probation, never tells Mr. Finch what special conditions, if any, he'd be subject to on his probation, simply says, let's do your jury waiver and I'll see you at 2 o'clock. There's no indication that probation then makes any instruction to him to meet with them out in the hallway, anything of that nature. It seems all parties anticipated there would be more matters before the court. And I also think it's important.
Let me interject. By this time, he has pled to some crimes and received a suspended sentence.
Yes, Your Honor.
Okay, so we can probably argue about this, but if it's reasonable to assume he's received a suspended sentence, especially because of his record, he understands he's going to be on probation. There's still the question of when that starts.
Exactly.
But at least there's two elements: when it starts and what the conditions are. But do you concede that in terms of conditions, don't commit any new crimes? He already knew that.
I mean, I think that is, and that's a great point, Your Honor, but I think there are standard terms of probation, obviously, that are delineated in the written order. But there's no indication that the judge had signed the written order at that moment, and she certainly didn't orally tell the defendant of any other conditions of probation, simply that she was imposing the agreed-upon sentence. But no, I think her order would be the written component.
There's no documentation of standard conditions by that period, or I guess if we concede that what I'll repeat the question, though. This defendant, given his record, is it fair to assume he knew beyond any doubt that one of the conditions of the probation, which he knew he was going to be on, was don't commit any new crimes? And so that piece of notice was satisfied.
I think it's fair to assume that he knew that it was going to be a condition of the probation he would potentially receive that day.
Okay, yeah.
But I also do want to clarify, again, his record was not before the violation judge in making that determination. She's not weighing what sentences he may have received in the past or anything like that. But certainly I do agree with the court's point that, yes, when he would have left the courthouse that day, we can all agree he would have signed the full and complete order of the court. The court would have authored her full and complete order, signed a standard condition of probation. But there are no implicit terms of probation. I think the Commonwealth used that language in their brief. Just saying, sir, you're now on probation, doesn't will a series of obligations to a defendant. It requires the order to be followed up in writing and placed in the docket. And it's unclear at this point, at 12:54, when they walk out of the courtroom that morning, whether or not the judge had actually signed that full order. And it's certainly the case that we know that the the Commonwealth did not offer that Mr. Finch had signed the order. Now, I understand the case law, McDonald, et cetera, it does say that a signed probation contract is not dispositive of this issue. I certainly recognize that. But in those, I think the three most relevant factual cases before the court that both of us cite in our briefs are McDonald, Riz, and Ruiz. And in those cases, there was a passage of time before the court ordered the probation, and somebody in the probation department maybe further articulated one's obligations to the defendant specifically before any violation. Here,
I take your point, and obviously we will consider it, that the green sheets were not put in evidence at the violation hearing. But there's no question that the defendant had signed the green sheet related to the pleas, which I can't remember which counts they were, but the 4 or whatever counts on which he pled, before he pled, right? I mean,
Certainly.
They hand up the green sheet. And the green sheet has a section on it about the consequences of committing a new criminal offense in the context of a guilty file disposition. I'm asking this because I spent like 15 minutes in district court in the 90s, and I just don't know the answer. Does that also apply to a suspended sentence or a probationary sentence? And I have a whole lot of other questions about the relationship.
filing, Your Honor, no. That is reserved specifically for a guilty file, that section. There is a notation in the green sheet certainly that says you need to be aware that if you are placed on probation on multiple counts, it could be imposed from and after. There was no oral discussion of that with the court on that colloquy hearing. And I apologize to interrupt if you had more questions.
No,
on
that's
that.
fine. I'm just trying to make sure I don't forget my questions, because that is the thing that happens. With respect to the suspended sentence, the Commonwealth cites and footnote 7, General Laws, Chapter 279, Section 1, and which apparently, I have no reason to disbelieve this, says that when a person is sentenced to imprisonment, the court may direct that the execution of the sentence or any part thereof be suspended, and that he, the defendant, be placed on probation for such time and on such terms and conditions as it shall fix. Do you read that statutory provision to mean that the imposition of a suspended sentence by order of law results in a probationary term?
If the court orders signs her order into, signs the order that does in fact impose the probation, yes.
But that's the piece I'm trying to get at. So it says the court may direct that it be suspended and that the defendant be placed on probation. Do you see those as two independent requirements? The court needs to say both your sentence is suspended and you are on probation, or one requirement, and there are no commas for whatever that's worth, your sentence is suspended, and by operation of my suspending your sentence, you are now on probation?
No, I do think it requires more than by operation of law, you are now on probation. I do think it requires a separate court order to come to be of what those conditions may be. And I think particularly in the case where you have a defendant who's essentially bifurcating charges on their same docket, I think it's really important to be clear about what's being imposed and when, which is why I cited the other authority later in my brief of when a court is imposing both incarcerated time and a probationary sentence. Whenever there's a risk of that or a possibility of that, I do think it requires a lot more of an explicit order.
Are you saying, can you have a suspended sentence and the person not be on probation during the suspension? Can that be?
I don't know that I've seen that, Your Honor, but I do think that it still requires a written order. I think the counsel below, and I think the Commonwealth focused on this argument more in their brief, I think counsel below spent a lot of time arguing that the defendant wasn't sufficiently apprised of all the terms of a suspended sentence. Well, I certainly don't want to concede that point. I think my brief, I'm really focusing on the fact was there even a full and complete order at the time at 1254 and between 1259? I don't think the Commonwealth proved that, number one, because we don't have when the order was signed by the judge at all. And I do want to take a moment while we're on that topic. The Commonwealth in their impounded or other documents does reference a record appendix or CA7 to highlight the docket sheet, the electronic docket sheet in the district court. In reviewing that before today's argument, I do highlight it offers further confusion as to what exactly happened and when in the district court, because the docket entries for 1/11/2024 are all out of order. The sentence, including that of the bench trial, all appear before any tender of plea is filed. There are then a reference to a probation order of conditions. Then there's also, notably, the motion for required finding being denied is docketed before the waiver of jury rights. So I think the docket adds more confusion. Further, as the court can see, there's an image, and the court scans in what image is attributed for each of those docket entries. And what's really interesting here is on 1/11, what they scan is both of the orders at the same time, only signed by the sentencing judge. And so it adds, again, further confusion as to when these documents were signed. Again, I think given the fast pace of the day, the way district court works, I would argue that this was all done at the end of the day. There's no, I apologize, Your Honor.
Your argument is that he didn't have notice that he was on probation, right? So going to what the notice was, we need to take into consideration what he was aware of at the time.
Certainly.
And part of that would be, wouldn't you agree, his history, his criminal history of his past criminal history.
That certainly could be part of it, but that was not proffered before the violation of probation
Well,
judge
let me ask you
in her
this.
determination.
Does the record have to be introduced into evidence, or doesn't every judge who's doing a probation matter have the person's record in front of them? And all parties know that. So, I mean, would it be something that would have to be submitted? You're asking us not to consider it, but as a matter of practicality, that is the case, that it's in front of the judge, right?
If Your Honor is inclined to consider the record in any event, with respect to the suspended sentences at least, we have to go back 11 to 15 years. I mean, to hold somebody to know exactly how something went down 11 to 15 years ago with precision, I don't know, is that a fair assumption?
Wait, sorry, I just want to make sure I understand what you're saying. His last criminal conviction before this was?
No, the suspended sentences that the Commonwealth offered in their impoundment are dated 11 to 15 years ago.
Okay.
It wasn't as though it was last year, it just happened, just got off probation in those exact terms. That was not the case. And I do think, I also want to highlight the fact that I think perhaps one of my strongest arguments too is that the sentencing judge below does not treat this conduct like a violation. And the law does allow for the court to look beyond the four corners of the order of probation. Now, the Commonwealth's last 2 pages of their brief use very incendiary language to suggest that it was a slap in the face that this defendant goes out in the hallway and commits a violation. That is not the way the sentencing judge took this behavior at all. Moments later, the prosecutor comes in, asks for a warrant because she's alleging the defendant committed a felony. The judge declines to issue any kind of warrant. Certainly, no one utters the word, this is a probation violation. It seems that they are all treating it as a potentially new criminal offense. The judge makes no effort to get Mr. Finch or otherwise bring him back sooner. And then when the parties resume at 2 o'clock or just thereafter, the court never addresses what alleged to have happened in the hallway. The prosecutor doesn't bring it up. The probation department doesn't bring it up. And certainly at the end of the day, after she makes her verdict on the bench trial, again, no one brings it up. And for the first time ever, we're talking about the special conditions of probation where the judge now is inquiring, should this be supervised or unsupervised? So a full discussion of what exactly her order of probation is going to be doesn't occur until after the end of that bench trial.
That piece, though, that you just mentioned, the supervised or unsupervised, is not actually that helpful for you, right? Because if I remember correctly, and I won't be able to find it in this moment, but the probation officer says something like, or the clerk says something like, oh, unsupervised like on the earlier charges, or supervised like on the earlier charges.
I don't know that I understand that that's the Commonwealth's argument. I don't necessarily see that as detrimental, Your Honor, because the record is silent as to when that conversation happened or when that original determination was made, and it's just as likely the judge either forgot or didn't know, or maybe, quite frankly, she could have signed this order during the lunch recess. I mean, that's also not unheard of. And the Commonwealth, had every ability to call whatever witnesses it wanted. They called a probation officer who had never met the defendant before the day of that hearing, who had no familiarity with the signing of that document in court. And when asked specifically at the hearing whether or not he knew that Mr. Finch was on probation at the time of the violation, he said, quote, "I can't say." And I think that that's fatal, I would suggest, and I'd ask that you allow the appeal. Thank you.
Thank you.
Good morning, and may it please the court. My name is Melissa Johnson. I'm an assistant district attorney in Plymouth County here on behalf of the Commonwealth. And I'm not going to apologize for the last 2 pages of my brief being incendiary, as my sister had characterized it. There was no confusion here. And it takes a special kind of audacious for a defendant to plead guilty to assaulting police officers, have a suspended sentence imposed, and minutes later go out in the hallway and threaten those very same police officers.
I hate to interrupt you, but here's what I'm focused on. I'm focused on something else. Ruiz, SJC. We have to follow the SJC,
Yes.
no matter what we think about that.
Of course.
Quote, probationers are entitled to clear guidance as to when their actions will constitute a violation of their probation. And so it seems to me what I'm most struggling with in your case is when probation's going to begin. What evidence do you have that before the alleged violation that occurred?
Well, Your Honor, first of all, sentences are effective when they are imposed. We know that from Rule 31. We know that from 279, Section 4. They are effective when they are imposed.
Well, in Ruiz, okay, but Ruiz illustrates that it's not anything like I'm not sure, well, not a universal principle. In Ruiz, the issue was, are these probationary terms going to apply at the time of incarceration? And in other words, contacting the victim was the fact pattern there. And the court said they can, but if you're going to do that, you have to give the defendant clear notice. So at least in that case, the failure, and they didn't, and so the court, the SJC held that was not adequate notice. So that doesn't seem to, your statement doesn't seem to answer that issue.
Your Honor, there was no indication here that the judge stayed the sentence until the end of the bench trial. So from all we know, it was effective when it was imposed right after the plea. We also have indications here from that the defendant knew what a suspended sentence meant. We know that he swore that he had discussed the green sheet with his attorney. We also know that the probation officer had signed that green sheet, so that there was discussion as to what those probationary terms meant. That was an administrative probation, so we know that. We also know from the defendant's record that indeed he has been on a suspended sentence before, and he knows what that means. He also knows what it means to violate that suspended sentence and what happens.
Right, so I'm still struggling though. None of that satisfies me. Here's what I'm thinking, what I'm focused on, that in this maybe sort of unusual situation, he's pled out to some things, right. And as your opponent suggests, the judge starts right in before lunch to the jury waiver, and then right after lunch we go into a trial. And so it's plausible, at least, that everybody would believe that this is all one unitary proceeding, and that whatever sentences are imposed will be imposed after the jury trial. Because, most importantly, if he's incarcerated, bench trial, if he's incarcerated after the bench trial, which was entirely possible, then unless the judge provides specific notice that the terms of probation from the pre-lunch pleas will apply during his incarceration, they're not going to apply. See Ruiz. So my point is that in this situation, at least, it seems that you've got to convince us that this probationary term has started before his trial.
First of all, there were 2 separate probation orders. And with a preponderance of the evidence standard, I think we've satisfied our burden that they were executed at different times. Those 2 separate, otherwise there would be just one probation order. Second of all, what if there was an acquittal after the bench trial?
Can you give me a record site for the 2 probation orders, and do they indicate the time that they were executed?
They don't indicate the time, but the fact that
so
there
how
were
does that
2.
help you?
the fact that there were two and it was not combined together. Again, we have a preponderance of the evidence standard, more probable than not that they were executed at different times.
So, but can you finish the sentence? I think you're saying that they were, I mean, I'm not trying to be tendentious, but I think what you're saying is, and this is the important part, that the probation order related to the plea before lunch was imposed, executed before lunch, before the crime.
It could have been.
No, but don't you have to prove that it was, at least by a preponderance?
More probable than not, yes. There were two separate orders.
Okay. So let's just say we don't agree with that.
Okay, and what if there were an acquittal after the bench trial? Would that mean that no, the sentence wasn't imposed? Surely that can't be the fact. A sentence is executed, it is in effect.
Right, no, but that's
opposed.
different, sorry. That's different than Ruiz, because there you don't have incarceration. And so where there's no incarceration, if he's, then you can, it's a reasonable inference that the probationary terms are going to be, well, I don't know what the reasonable inference is actually, but I think that you still have to satisfy us, at least by a preponderance, that he received the notice of when his probation was going to begin. That's what I'm still searching for.
It began when the clerk pronounced the sentence. And that defendant was not stayed on the record. That defendant heard he had already pled guilty. He had a full-on colloquy where he admitted to assaulting these police officers. And then the clerk pronounced the sentence, a suspended sentence, right there and then. So I do not believe the defendant at that point thought, oh, I have free rein for the next few hours to threaten the officers that I just pled guilty to assaulting. I don't believe he thought he actually had free rein to do that. I think at that point, the trial court executed its authority to impose a sentence. That sentence was effective then and there, and that defendant knew he was under the terms of that probation up until for a year.
So you have used the word probation in connection with using the words suspended sentence.
Yes, Your Honor.
And what the clerk said is, on this docket, guilty 10 years, which was really 10 days, suspended for 1 year, that date being date. Counts 5 through 9, guilty 1 year in the House of Correction, that is suspended to this date. The other counts are going for bench trial today. That is the entire pronouncement of sentence there. So I have two questions for you. One, what allows us to conclude, and this may be a very dumb question, but just answer it as if it's not, please, for my ego. What allows us to conclude from that statement that the defendant was aware that he was now on probation? And two, when we are looking through a due process lens at whether the defendant received the process he is due, do we overlay that lens with the defendant's own experience? In other words, is it a semi-subjective or at least informed by the fact view, or are we looking at it as if, you know, a naive 21-year-old who's never had any interaction with the jury system stood up and heard this sentence?
Well, I'll take the second part of your question. First of all, you can, this court and the hearing judge can take into consider all of the circumstances surrounding whether this defendant had fair notice. We know that this defendant had fair notice in this case that a suspended sentence meant probation for a couple of reasons. Number one, during the plea colloquy, he swore that he had discussed this particular plea and the terms of the plea with his attorney. We know from his experience that he knows what a suspended sentence means, what that term means, and what it means to violate that. So we know that from his plea colloquy. And then, of course, the sentence was pronounced. So the hearing judge took all of this into consideration to make the finding that it was more probable than not that this defendant had fair notice that the pronouncement of a suspended sentence, just using the term suspended until X time, meant that he was on probation at that moment. Otherwise, why would the clerk pronounce it? They could simply stay that sentence until the end of the bench trial. If that's truly what the judge intended, if that's truly what the parties wanted, the judge would have stayed the sentence. Okay, this is going to be your sentence, but we're going to stay the imposition of the sentence until the end of the bench trial, whatever happens then. That didn't happen here. And we know under Rule 31, we know under 279 Section 4, we know under McLaughlin, who gives the judge the inherent authority to do that she never did that here. So the parties' understanding in that moment was that sentence was a go right then, as is in most cases, unless it's stayed. It is effective when it's imposed. Okay, so those are all the things that the hearing judge had before her. She had the transcript. She had the file before her. She had the defendant's record before her. All of these things that she can take into consideration aside from just merely the pronouncement of that sentence.
Well, and I'm going to get you back to my dumb question too, but she also knew, I mean, to the point about the BOP, she also knows what a green sheet says.
Absolutely.
So the fact that it wasn't, that this defendant's green sheets weren't admitted in evidence, I suspect you would say is not fatal to any argument you have based on the green sheet, because you're in district court, everyone's seen it a million times, there's no question he went through it with his lawyer, there's no question he said under oath that he understood it, there's no question he signed it.
Absolutely, and that was in the transcript, which was admitted as an exhibit. It referred several times to the green sheet, and of course it's part of the clerk's file, so it's part of the record. It's going to be the documents that are before a district court judge when they are trying to decide whether someone should be violated on probation.
Okay, so does suspended sentence mean and also you're on probation, and if so, why?
Automatically, yes. 279 Section 1, the clear and plain meaning of those terms is when a sentence is suspended, the judge must put the defendant on probation. Otherwise, it's a stayed.
It doesn't say must, and that's the thing that trips me up.
They may suspend the sentence, but once they do suspend the sentence, they have to be on probation. There was a case that came out 5 years ago, Beverly, which is the same idea with a quaff. If you are going to kind of delay the imposition of the actual committed portion of a sentence, the defendant has to be held on something. There has to be some kind of probationary terms on him. So that's what Beverly said in 2020. In this case, the judge, yes, may suspend the sentence. She doesn't have to automatically commit him to jail, but if she's going to do that, then there has to be a probationary sentence. Now, it could be administrative probation with really no special terms, as it was in this case, which kind of comes to my point. All the parties understood that this was just an administrative, unsupervised probation. Not much discussion needed to be had between the defendant and
Before you move to that, though, do you agree that the gloss that you put on the reading of 279 Section 1 doesn't address this question, that this quote from Ruiz, in addition to the unambiguous guidance about the conduct prohibited, probationers are entitled to clear guidance as to when their actions or omissions will constitute a violation of their probation. In other words, even if we agree that suspended sentence equals probation, you must be placed on probation, that doesn't answer my question, when does probation begin? I think you're saying when the clerk announces it, it's just the only reasonable conclusion is it begins immediately.
Yes, Your Honor. That is what the case, that is both what Section 1, Section 4 of 279, they all say, and Rule 31.
Wait, where does Section 1, what language are you focusing on?
If you take all of those ones together, and the thing with Ruiz is that was an on and after sentence. That was an on and after sentence. It was a completely different situation from here. So yes, the clerk had to be very...
No, that's not, sorry, I don't agree that, I read it carefully. The controlling point is that it was a probationary term within the incarcerated, whether that was going to be
Right.
enforced within the incarcerated period. And the court very clearly said, if you're going to do that, you have to give clear notice of that. The temporal piece of this, we are requiring clear notice of the temporal piece. It didn't have to do with it being on and after.
So if the clerk announces the sentence, how is the defendant supposed to know when it's effective?
Okay.
Clearly, Rule 31 is saying that these sentences, once they are pronounced, then they are effective upon pronouncement.
So the fact
Otherwise,
that
unless they are stayed. Now, if there's a unusual sentence such as an on and after, sure, they have to be specific about that. But this clerk could not have been more clear that this sentence was a suspended sentence. The defendant, given his record, understood exactly what that meant, and given the green sheet that he had already discussed, knew exactly what that meant. And the judge, nor the parties, no one said that this sentence was going to be stayed until the end of the bench trial. If there are no further questions, I'll rest on my brief.
Thank you very much. Thank you to the parties. Well briefed and argued. The matter is submitted. Next case on the list is Commonwealth versus Eric Mitchell Rivera, 24P 810.
Good morning. I'm Allison Corey, here for Mr. Rivera, who asked me to let you know he's here observing. So, the big issue in this case was consent. That's the element that just really is everything to this case. And there are kind of two problems with the consent element. The first was the failure of the judge to give a missing witness instruction. And the second goes to the instructions after argument dealing with consent, okay? So I'd like to start with the missing witness instruction. There are four things, as we all know, the four things that the court looks at in determining whether a missing witness instruction is appropriate. Number one, is the missing witness one that you would expect the Commonwealth would call and would give important testimony? In the case of when the missing witness is the victim, the answer is yes.
Well, is it though? I mean, when the missing witness is the victim and the whole thing is on videotape, really clear videotape. So you have to say that, right? I mean, that's the facts here, right?
Yes.
So,
Yes,
are you still saying the same thing?
yes,
Okay.
yes.
So
And
Shotvet says, first of all, the judge should consider the strength of the case against the defendant. In
Yes.
other words, if the case is really strong, then it's less likely that you're less entitled to the missing witness instruction, right?
that's true.
So would we be wrong? What's wrong with the analysis? I look at the video, I say, it looks incredibly clear that there is no consent because the complaining witness, the alleged victim, was sleeping.
Well, that is something for the jury, a fact question for the jury, which, and where the problem with the consent instruction, it's why that problem comes in. But in a sexual assault case, an adult, the answer is yes. You would expect the Commonwealth to call this witness. Regardless of video, that is the only witness.
Why
who
is
can
it
testify.
regardless of video? I feel like that just doesn't make sense to me. It's the strength of the case, not, it's the strength of the case, not this witness is the central witness, right, I get that, but if the central witness is corroborated by really clear videotape, then it seems reasonable to say that the central witness becomes less important.
Okay. Let me go at it this way. There are definitely cases that allow substitute evidence on the issue of consent. Okay? There are. And those cases, the ones I found anyway, deal with extreme alcohol or drug intoxication, so that the witness is unable to consent, legally unable to consent. The substitute evidence that has been allowed for this key element of consent has been very specific observations about what the observer saw. So, for example, it's the Scarborough case. I think that might have been in both our cases, but it's definitely in the Commonwealth. In the Scarborough case, the substitute evidence was that the victim's head was tilting back, her eyes were rolling, she was swaying back and forth, she fell. Okay, specific. Here, we have the observer, the man who saw this, testify just a conclusory statement. She was sleeping. She was sleeping.
Why
She was
isn't the
sleeping.
video substitute evidence? Why
Sorry.
isn't the video very clear and specific substitute evidence for the victim testifying?
Because we don't know that she was sleeping.
But we can see her.
Yes, you can see her
And
with
we,
her.
unlike the eyewitness, we can pause the video, we can slow it down, we can back it up, we can watch it 47 times if we want to. Probably someone who's more technologically capable than I could actually zoom in on it. So why is that inadequate?
It's inadequate because it's not conclusive. She may have just been sitting there, resting her head, closing her eyes
Right,
She
so-
may
while
have, but
waiting.
that's the jury's job, right?
That's right.
But you said these are factual questions for the jury, but here's what I'm struggling with. The judge has to make a preliminary determination whether to give a missing witness instruction. The case law is clear that a missing witness instruction is not given lightly. It's a very powerful instruction. And so the judge should be careful about giving one. And the first factor the court has to consider is the strength of the case. Now, you would say that's the jury's determination, so that the doctrine would be, you may not consider the strength of the case. That's not the doctrine. The doctrine is, you must consider the strength of the case. And so it seems to me that your analysis can't be right, that to simply say, bat that away by saying that's a jury question. No, if the strength of the case, if the case is strong, in this case, if the evidence, the video most importantly, is strong evidence that she was sleeping, then that seems at least relevant, appropriately relevant to a judge, no?
Definitely a factor, sure. But it doesn't make the Commonwealth's case strong enough because, and I'll tell you why, anybody who has sat in a waiting room, an emergency room, waiting room, is waiting and waiting and waiting. She could have been closing her eyes. Absolutely.
Do you want to move on to the other factors?
Sure. Okay, I'm going to jump to the fourth factor as the way I have it listed. Would the missing witness instruction be unfair to the Commonwealth? Would that have been unfair? The answer is no. The Commonwealth was relying on the theory that she was sleeping. And they knew that they were going to get that instruction about sleep being incapable of consent. So they knew that they were going to get that. And they ran with that in closing. she was sleeping, she was asleep, she was asleep, she was asleep, without even prefacing, I suggest you could find she was asleep. They're making this a factual assertion, she was asleep. And then what comes next? The judge's instruction that if she was asleep, she can't consent. So given the way that came out in this case, to have the prosecutor and the judge say she was asleep, and the judge, if she was asleep, she can't consent, without giving a missing witness instruction, oh, but she's not here. You can take that into consideration. That is what makes it unfair.
Well, but I mean, with due respect, the question isn't whether it's unfair. The question is whether the defendant, and I know you were not trial counsel, whether the defendant at trial made the necessary showing that the defendant was entitled to what Justice Wood reminded us earlier is like a big deal instruction, right? It's not just someone isn't showing up. It puts a finger on the scale, and I think rightly, but who cares what I think, the law says we don't put our finger on the scale in just any situation. You need to show these four things. And not only, tell me if I'm going wrong about the record, but defense counsel never filed a motion for a missing witness instruction, never explicitly made a showing or attempted to put in proof as to the four elements of the missing witness instruction. It seemed like it all kind of happened on the fly, and, you know, that happens, obviously, but then that's the record you have on appeal. And so what we're doing is looking at that record and saying, did the judge commit an error on this record by not giving this instruction, which we all agree there are four factors that need to be shown. And at least one of those factors that we haven't gotten to yet is that the witness was available and not unfriendly to the Commonwealth. Is there any evidence at all in the trial record of that?
I suggest the burden of that element is on the Commonwealth.
It's not, though, because it's on the burden is on the proponent of the instruction. And in this case, that's the defendant.
Well, the Commonwealth has to provide a valid reason for non-production.
They don't.
Like unavailability, that she maybe had a fifth.
Was she on their witness list?
I believe she was.
Did they represent at pretrial hearings that she was going to show up and testify?
There's nothing on the record about anything that happened before trial.
I could see that argument if your predecessor could say, we were led to believe that she was showing up, and we based our case on that assumption, and then at the last minute, she failed to show up. That's at least an argument. I'm not saying it would be persuasive to me, but it's something. I didn't see anything in this record on that point. And, you know, even if you could make the other three, which who knows what the panel will decide, but that alone seems to me dispositive, because you need all four.
Well,
Wasn't there, in fact, evidence in the record that the Commonwealth had no contact?
there was a mention of that. They hadn't had contact.
Right, so
but
to the
that's
extent
not
that there's any evidence on the record about the Commonwealth's ability to bring the victim in, it's that they didn't have that ability, right?
I disagree. They said they didn't have contact without explanation. We've tried to reach her, we couldn't. We tried to find her, we couldn't. We reached out to her, she won't testify. Nothing like that. Just that we haven't talked to her. And that's not enough to refuse the instruction. It would have at least counterbalanced the prosecution saying she was asleep, she was asleep, she was asleep, with the judge's instruction, if she was asleep, she can't consent. The missing witness instruction would have given the jury pause. They could have said, well, why isn't she here? Maybe she could consent. Maybe she did consent.
The closing argument by defense counsel very thoroughly, and your brother says inappropriately, explores that line. It's also obviously available during cross-examination, right? Where is she? Where is she? Where is she? If this was non-consensual, wouldn't she be here? Wouldn't she want to vindicate her rights? Why is she not here?
Right.
How is that not enough?
It's not enough because of the instruction from the judge that used the same conclusory term as the prosecutor. She was asleep. She was asleep. Well, maybe she wasn't. And that's why the instruction was so important in this case. The jury should have been allowed to consider, well, maybe she wasn't asleep.
Wait, sorry, the jury was allowed to consider that, right? I mean, the jury was allowed to consider the argument, weren't they? That she was not asleep.
No, no.
Why not? The judge didn't, why?
Unfortunately, defense counsel's closing kind of nixed that. Defense counsel, I don't know if it was an accident or misspeaking, but he did say she was sleeping.
Okay.
So, thank you.
Thank you very much. We'll hear from the other side.
Thank you very much. Good morning. May it please the court, Kenneth Steinfeld for the Commonwealth. With me at council table is the trial prosecutor, Emery R. Donatelli. I'd like to begin with the point that Justice Hershfang and to some extent Justice Wood has already addressed, and that is the fact that the defendant was able to make a very strong, albeit very, very improper argument in his closing that the victim, quote, voted with her feet, chose not to be here, knew what the real deal was, wanted no part of it. So to credit the claim now would mean that the incremental benefit of the instruction on top of what the jury had already been argued would have made all the difference, which is unsustainable. The jury were never told, you can't consider that argument. So had the judge said, you can consider the argument that the defense counsel has just made to you, would have added virtually nothing. And that's entirely apart from the defendant's utter failure to establish any of the factors necessary for a missing witness instruction. And that is clearly because he had no intent on asking for it. It was not until the charge conference, following the arguments, that the judge said, what about a missing witness instruction? And defense counsel said, yeah, sure. And in fact, the victim, to Justice Hershfang's question, the victim was not only not on the witness list, but in her opening statement, the prosecutor said, you will notice that she's not on the witness list. So any idea that the defendant was surprised that she was not there is just not supported by the record at all. There's a fundamental problem in this case for the defendant, and that is that it was virtually indefensible. So were there any error in this case, and I don't think that any of the claims even comes close, there could be no prejudice. This was, as has been stated, very, very clear surveillance footage of a woman who was clearly passed out, and the idea that she had her eyes shut but was conscious for 34 seconds while he rubbed her crotch is well, I don't want to say absurd, but it's not, I think it would be very hard for a jury to credit that. They had every right as jurors, as people, to see when somebody is asleep or not conscious or passed out. And of course, what's important here is were they able to find that she was unable to consent and that this defendant knew or should have known? And I think that's absolutely clear. It would be hard for anyone to look at that and say that she was able to consent. And her conduct on the video, that's even excluding the comments that she made that came into evidence, was so inconsistent with consent. Again, you couldn't have scripted it any better. The moment he makes physical contact with her skin by trying to put his hand down her pants, she's up and screaming, very, very upset. She walks away from him immediately. She goes to get help. She demonstrates, it's sort of hard to watch a lot of the video. She demonstrates to one of the officers what he did to her. This is not the conduct of a person who's consented to what has just gone on. And obviously, if someone is asleep, then she cannot consent at all. And the fact that he rubbed her back earlier does not at all lead to a finding that she impliedly consented for him later to touch her in the crotch, or said at some point, you know, while I'm sleeping or something, feel free to do this. I mean, that's just absurd. That's not what happened here. This is an absolute sexual assault on tape, the likes of which, I don't know what my experience has to do with it, but I've never seen before. And so I don't think there could possibly be any prejudice arising from it. And the only statement made at trial by defense counsel in support of his request for the missing witness instruction, which obviously came only after the judge had brought it up, was he said the victim's testimony would have been useful one way or the other. That's all he said about it. He said nothing about she would have testified adversely or any basis to find it or anything about efforts to find it or why he could not subpoena her. So on its face, that's an inadequate record, as I said, because he did not plan to do this ahead of time. It was purely at the suggestion of the judge. So I don't think this court should credit his claim that the incremental benefit from that instruction on top of the improper argument would have been enough to sway the jury. I do just want to speak briefly to the second, third, and fourth claims. Each one has an inherent structural flaw that just stops it at the gate, doesn't even get out of the gate. As to the ineffective assistance claim for failure to object on the grounds of prior exclusion, that is structurally flawed because those statements were not previously excluded. His claim that the judge should have recused himself because he had presided at the tender plea hearing is also structurally flawed. She admits that this court has no power to change, that there's binding precedent that says the judge didn't have to recuse himself, so she's just asserting that claim here to preserve it for FAR. So that doesn't even, leave the station. And third, her sufficiency claim is based explicitly on an argument that evidence should not have been admitted. And of course, it is black letter law that during that a sufficiency claim is based on all of the evidence that was admitted, regardless of the propriety of its admission. I don't have anything further to say, and I'm happy to rest on my brief unless the members of the panel have any further questions.
We're set.
Thank you.
Thank you very much. Thank you to both parties. So at this point, we'll call the next case on the list, Kimberly Henderson versus Stephen Bosco, 24P 1300.
Good morning, Your Honors. Attorney Adam Sherwin for the appellant, Stephen Bosco, who's here today. May it please the court. Your Honor, today's case is an appeal from a landlord-tenant civil trial from the Western Housing Court. This case began as an eviction that my client, the landlord pro se, brought against the tenant pro se. The two parties at the first mediation resolved the case among them, the eviction case among them, where my client agreed to take rental assistance and saved her tenancy. The civil cases were then transferred to the civil docket, which are the basis of this appeal. It went to a 3-day jury trial where the jury awarded $885 in damages, and the court then later awarded the tenant over $37,000 in attorney fees. And that's
your opponent's going to say, no, you're completely mischaracterizing the damages, $1,000 for breach of warranty. $2,500 for emotional distress from the breach of habitability, for trying to get rent that he didn't deserve, tripled under 93A to $7,500, $3,800 for security deposit, and then $10,900 for rent abatement. Put that all together, and you get over $20,000. So do you disagree with his point that you're just getting the basic math wrong?
I do, Your Honor, and giving my brother the benefit of the argument, I think he's trying to ask the court to look, break down those claims. Only one of those claims entitle him to attorney fees, which is the quiet enjoyment 93A, the $7,500. So if the court were to focus on that in lieu of what I was focusing on, the $885, there's still a disproportionality between the attorney fees. It's over 5 times the actual amount of the actual damages under 93A. So if a court were to incline to look at it my brother's way, I would say that there's still quite a disproportionality, regardless if you take my view or my brother's view.
So in the Supreme Judicial Court's Twin Fires opinion, it's more like a 10 times difference between the damages and the fees. Why is that not fatal to your proportionality argument?
Well, I want to be clear about my proportionality. I'm not suggesting any way, a manner whatsoever that the fact that it's disproportionate means that he doesn't get, that award shouldn't be upheld. I'm not saying that at all. What I am saying is that it demands a closer, more scrutinous look. My authority from that is based on the Killeen case, the Killeen-Westband, where it says the judge has to focus on the relationship with precision when you have a disproportionality between the amount.
So I just want to make sure I'm following, because this feels to me a little different from what I read. You're asserting that you're not saying that the amount of the fees is wrong because it's disproportionate to the recovery for which fees are allowed, but rather that the judge did an inadequate job of sort of documenting the reasons for that fee award?
That's correct, Your Honor. I'm not saying that the fact that it's disproportionate alone means that the whole award should be tossed out. I'm saying that the court's analysis wasn't proper. The court didn't go.
So if you were to win, I just want to make sure, because you have a number of arguments that I'm following on this one. If we were to agree with what you're arguing on this point and give you what you want, would that be a remand for further findings supporting the award of fees?
That's correct, Your Honor. Based on Killeen, we would be asking the court to take a detailed look and giving a more precise analysis between the actual work spent for the one count that entitled the tenant to attorney fees.
And when you say the court there, I want to make sure we're talking about the same court. That's not us.
That's not this court. I don't think it's proper for the appellate court to be determining attorney fees at a trial matter. I think it's proper for the trial court. I am going to talk about 3 particular points to the panel, unless you have any specific questions. I'll be addressing the quiet enjoyment issue related to the alleged unpaid rent, the habitability issue and my client's offer to relocate the tenant, and the attorney fees, which we spoke about briefly. Turning to the first point, the allegation that was raised here was an allegation based on violation of a quiet enjoyment on a claim that my client included alleged unpaid rent as part of the case. The allegation was that because that was included in the notice to quit, that was a quiet enjoyment violation. We submit that the trial court erred in not granting a directed verdict at the close of evidence on that matter. Important point about that is the only evidence on that matter that was introduced. The only allegation was that disputed rent was included in the notice to quit. Nothing further. This, of course, was a non-payment of case. I shouldn't say of course, but this was a non-payment of case where there's no dispute whatsoever that the tenant owed rent. She owed rent to my client.
Yeah, but the thing that their point is that your client, knowing that he wasn't entitled to this rent, tacks it on, and so creates serious emotional distress when he's tacking it on to a notice to quit, like get out of your apartment, and that's emotional distress. What's wrong with that?
Your Honor, the court said in the Rahman case, the court said that just commencing eviction proceedings alone isn't enough to trigger quiet enjoyment. The relevant, important point here is nothing happened beyond including this alleged rent in the notice to quit.
Rent to which you're not entitled, and which reasonably she might say, well, I can cover the rent that I owe this guy, but I'm not going to be required to cover the rent that the prior owner had, so telling me that I owe this is really jacking up the likelihood of eviction. Why is that appropriate for him to be able to do that?
Well, again, going back to Rahman, I'd submit that was the same scenario there. That case was filed improperly. The court found it was improper. The point they made, though, is it went no further past that.
No, that was no. Right, I remember now. That was a bookkeeping error. The crucial distinction in Rahman, which your opponent's going to tell me, was there was no bad faith in Rahman because the landlord thought, because of a bookkeeping error, that he really was entitled to that rent. Here, by contrast, your client knew that this was money owed to the prior landlord, and he didn't have any basis for that. And he ultimately conceded he didn't have any basis for that, right? Isn't that a huge difference?
I respectfully know, Your Honor, I don't believe it is. Quiet enjoyment.
Well, did I get my facts right, first of all?
You got your facts correct that in Rahman, they did find it was a clerical error. I don't dispute that was part of the case. What I dispute, though, is that quiet enjoyment doesn't look at intent, it looks at conduct. So in this particular case, it isn't relevant what the underlying reason was, even if you take the position, and we vehemently dispute that my client did this on purpose, but assuming the court were to look at that and say, hey, he may have done it, there may be evidence to support that, we never look at intent, we look at conduct. What was his conduct? In this particular case, nothing happened in this case that wasn't going to happen otherwise. He had every right to send the notice to quit, he had every right to do the eviction. Nothing further went by that. They did a mediation.
But I'm sorry, I need to pause you here to understand the contours of what you are calling conduct, because doesn't the notice to quit include because you owe X dollars in back rent?
Yes, it does. But
so if X has been artificially, deliberately inflated, isn't that part of his conduct?
I mean, I think it's conduct, but I don't think that I think it's more of a question of intent, whether we decide whether it was done on purpose or not, as I believe Justice Wood was trying to, was mentioning. I don't think that distinction is material for the case. I think the material fact is what actually happened. She was only served with a notice to quit. Nothing further went past that. The parties resolved the matter. He accepted rental assistance, and he forgave the amount of rent. And again, nothing in this particular case happened. It happened in this matter that wouldn't have happened otherwise. I submit that this is completely apart from the Home Savers case, which my brother is going to argue. That was a case where the landlord went well beyond that. The landlord, and he knew that he had no basis for doing the eviction, continued the case. He was on notice about that.
I'm really struggling with this. So to break it down and make it simpler, let's say she's withholding rent, which she's allowed to do because the apartment is falling apart. So she's putting that money aside. And she knows that it's one day she could owe your client back rent. And so she's got a notice to quit. Let's call that X. That's the amount of money she's withheld. And he's saying, you owe me X. And he's right about that. You owe me X unless there's a deduction for the breach of the warranty of habitability, which we'll get to later. But he gives her 2X as the amount owed. Now she's looking, it's not just a notice to quit, it's not just an eviction. It's, I can pay X, I put that money aside, but 2X, I can't pay that. And I shouldn't have to pay that. I should only have to pay X, worst case scenario. That's completely different. That creates the emotional distress. How are you saying it's okay? I'm just not getting it.
I'm not saying it's okay, Your Honor. I'm saying it shouldn't rise to the level of quiet enjoyment. The scenario that you gave, if the tenant went to the landlord and said this is wrong, and the landlord said, no, I'm continuing the case regardless, that would be quiet enjoyment. In this case, the tenant raised the issue. The tenant went back to the landlord and said, hey, there's an error here. On writing, they agreed to look into the matter. He dropped the rent later. So I would submit too, the relevant point isn't that the relevant point is that the relevant point is if he went past simply filing the eviction or the notice to quit or the filing eviction, that's when quiet enjoyment gets triggered.
Yeah, but the judge found, never mind. No, I'll withdraw that.
Okay.
Go ahead.
Could I just ask you what do you consider to be quiet enjoyment?
I'm sorry?
What do you consider to be quiet enjoyment or a quiet enjoyment claim?
In the scope of quiet enjoyment is a substantial interference with a tenant's tenancy. In a scenario like this, I would submit that the landlord would have had to do much more than just send the notice to quit. In this case, if he had continued the eviction case, despite the fact that the tenant was saying that this rent isn't owed, that would be a home saver scenario that I would submit would rise into quiet enjoyment. But nothing happened here that wouldn't have happened otherwise. He had every right to send a notice to quit for the owed rent, which was not in dispute. Let me turn to the issue of the habitability. In this particular case, Your Honor, the landlord and the tenant in this case raised a couple of habitability issues. In particular, the tenant raised a number of claims about the walls, ceilings, and floors. She introduced that as part of her case in chief. My client was prepared to offer testimony that he was ready, willing, and he was not able to address those matters because of different debris and different dust and different work. He wasn't able to address it while she was residing in the property. The court prevented my client from being able to make an offer that he was willing to relocate the tenant. He was willing to temporarily relocate her so he could get that work done. We would submit that was an error. That was an attempt to mitigate the damages. Warranty of habitability is a contract claim, and as in any contract claim, the landlord has a right, the non-breaching party has an obligation in the appropriate circumstances to mitigate the matter. And we would suggest here that was an error for the court not to allow that. The jury should have been able to make that decision. The jury should have been able to look at the matter and make a decision whether or not it was appropriate in that circumstance. If they had that evidence, we would suggest that it was very possible that the jury could come back and find the length of the defect was significantly less longer than it was. That would have impacted the eventual award of the damages.
So, from my understanding of the record, and I'll say what I think I know, and then please tell me where I've gone wrong. The offer to relocate was that he would put her in another apartment. I can't remember whether he offered to pay her moving expenses. There was, as far as I saw, no record evidence about whether her rent would be the same, no record evidence that she would be entitled to move back into her original apartment at the same rent after whatever this time period was, and no record evidence regarding the circumstances under which she would be residing in this second apartment, whether it would be under her original lease, a modification. I know she was on a month-to-month by then. Am I wrong about any of that?
It was a temporary offer to relocate. So if she was going to go back to the property, it was going to be reduced rent, and he was going to pay the moving expenses.
Is that all in the record?
Some of it is. We weren't able, obviously, because the judge denied that evidence, that offer. We weren't able to get in everything. But I would submit there's enough for the court to consider that there was an offer to temporarily relocate her from the property. And I would submit the court should have had that. The trial jury should have had that evidence. It could have been a factor here.
Sorry, I just want to drill down on that. So you're saying the record evidence will show when we go back that he was going to let her move back in to the same apartment, now renovated, at the same rent?
Yes.
Okay.
Yes, but temporarily relocate her from a property.
Yeah, but once he's done, he was going to let her. The deal, the deal was you can come back to the same apartment at the same rent.
In a better condition.
Okay.
Yeah. I would submit again that this was relevant to the issue of mitigation and damages. You know, if you take a look at the brief, my brother obviously makes a number of characterizations that my client wasn't diligent in taking care of this apartment. I would submit that a lot of those are a little bit of distortions. If you take a look at the evidence and you take a look at the jury's verdict, the jury came back and said that my client was not negligent, he was not reckless in maintaining the property. And I would submit that this is the kind of scenario that we want to encourage this. We want to encourage landlords to do what my client did, trying to rehab apartments. He went into this, he bought this property for the full purpose of trying to get it, better condition. We should encourage conduct like that. Your Honor, I see my time's running short, but regarding the attorney fees, I would submit again very quickly that the court should take another look at the attorney fees because there is such a disproportionality between the two. It demands a further look. The court again made a ruling that this case was mostly about conditions. Only a small part of the case is about what awarded them attorney fees, and that alone is a justification for a remand. If the court has no further questions, I'll rest on the rest of my brief.
Thank you.
Good morning, may it please the court. I'm Joel Feldman for Kimberly Henderson. Your Honors, Ms. Henderson defended herself in an eviction case in which the landlord sought thousands of dollars in rent, which he knew was never owed to him. The housing court in its 93A decision found that the likelihood was that the current owner had learned from the prior owner that the tenant might have owed him rent and tried to collect it for himself. She also withheld rent because of serious substandard conditions. And when she prevailed in the case, she sought and was awarded her costs and fees. She now asked the court to affirm the jury's verdict in the case after the multi-day trial, affirm the court's decision on the 93A claim, and affirm the court's decision on its award of fees. So there are three separate sets of claims. One is the illegal rent collection, secondly, the defective condition, third, the attorney's fees. I'll start with the collection of rent under 186.14. I just want to note briefly that we have put in our brief that we say that this was waived because the notice of appeal did not specifically appeal this issue. The appellant had the right to just appeal the judgment, chose not to do that, went through a series of particular orders, did not appeal this. As to the whether it's a 186.14 violation to have done this collection of rent, I want to note that the appellant notes in its brief at page 26 that evictions can cross the line into a quiet enjoyment violation. So there's an admission this could be a 186.14 violation. Just on these facts, perhaps it's not. I want to go through briefly what the facts were. Number one, there was a request for admission that said the landlord knew he was collecting rent that was waived by the former owner, admitted. So there's a conclusive admission that he was seeking rent he knew was not owed to him. Secondly, there was testimony, there was no conversation at all with the former owner about rent. Third, no document showing any legal right.
Can I focus on his response, I think, is that his client, when confronted with this by your client, the tenant, withdrew that after the notice to quit. Do we have a chronology there?
Yes, Your Honor, that's a great question. So the notice to quit said that I think it's $17,000 or $18,000 was owed, $11,000 of which was to the former owner. That's the notice to quit. You have a right to cure within 10 days under state law. So the cure would have been paying $18,000. Secondly, there's a summons and complaint that can then get served with $23,000 owed. So now we're notice to quit, and then months later, summons and complaint. Then months later, what's now called a first tier event, which is a mandatory mediation in the housing court. And the agreement says, and it's in the record, the landlord says $23,000 is owed, tenant disputes that amount. And then what was agreed to by the pro se tenant was that the burden would shift to the tenant to have to prove she didn't owe the money. So that was the voluntariness that you just heard here. And then ultimately, the way this was resolved was the tenant and the landlord asked to have RAFT, the rental assistance, emergency rental assistance program that pays off arrearages, asked for the $23,000, including money not owed to him from the state, and designed a fake ledger, that is, a ledger that showed the money was owed to him, that was submitted to the housing court and was submitted to the state RAFT program.
But at least in any event, for our purposes, for our purposes though, in the quiet enjoyment, that the inflated rent request is still out there, has not been withdrawn by the time of the complaint.
That's correct.
Right, okay.
Oh, no, only withdrawn. Remember, he's still seeking it at the mediation 2 months later.
He's seeking it through RAFT funds. I get what you're saying.
Yes.
Yeah.
So these are facts. These are facts, not just intentions. These are one after the other, continued attempt to collect. The jury found it was a serious interference with the tenancy and determined that it was a quiet enjoyment violation. As to the Rahman versus Home Savers issue, Rahman, the court very clearly talked about inadvertence and bookkeeping errors. Home Savers talked about despite the tenant's attempts to get correction, this continued, it continued. That's exactly what happened here. This is not inadvertence, this is incredible intentionality based on the facts before you. I'm just going to address the issues that were addressed by the appellant. There are 6 different issues, so I think I'm just going to address the issues that the appellant addressed here. I do want to say Just one brief word about the 93A claim. In the appellant's brief, they note that the court somehow didn't on its own determine that there was a 93A violation. The court went through in quite a bit of detail the facts that I've just described, including the fact that it inferred that the landlord was seeking to collect rent that was not owed to him in an opportunistic way. As to the renovation of the apartment, Your Honors, there was a motion, the motion before the court, before the trial, the landlord sought a court order to force the tenant to move in order to quote-unquote renovate. That motion, which again is also in the record, was done under the state sanitary code, 105 CMR 410. The code permits a judge and the Board of Health to say, this place needs to be condemned, you need to move out of this in order to do the work, or it's so serious that you're going to need to move for a few weeks. It is not the routine matters before the housing court around conditions issues that tenants are required to leave in order, for example, to put down mouse traps or in order to fix a ceiling. The court found that the landlord, rather than trying to repair the apartment under the state sanitary code, was trying to use the opportunity to renovate the apartment. There is not a single case in the Commonwealth that says that's permissible, to require a landlord to leave because you want to quote-unquote upscale the apartment. Again, in particular instances under the state sanitary code, it might be required because of the work you're doing. There was no evidence before the jury or the judge that there was going to be a lack of health for the tenant if the landlord started to do the work, that somehow the tenant was going to be harmed by the work. That's not in the record at all. There's a miscitation in the record that perhaps some sawdust might land on a couch, and that's in the record cited by the landlord. That's record appendix 471. But instead, there's evidence that once the Board of Health cited the landlord for the problems, he immediately did all the work. And in fact, was arguing and presented to the jury, there really wasn't much work, it really wasn't a state sanitary code violation, and it all got done rather quickly while the tenant was in place. So in order for the court to decide that a tenant is going to have to move if there are repairs to be done, that would enact essentially a waiver of the state sanitary code that requires the landlord to make repairs for this tenant who bargained to live in this apartment with conditions that don't violate the state sanitary code.
And again, I don't want to go down a rabbit hole, but just quickly, the chronology again of the notice to quit, there's two different kinds of repairs. There's repairs that are violations of the state sanitary code, and then repairs like the sagging ceiling, the walls, the floors, which I guess are not violations of the sanitary code. But my real question is the chronology of the violations of the state sanitary. You don't dispute that he did address the violations of the state sanitary code. Was that before or after the notice to quit? And how long after, if it was after?
So the purchase of the property was March of 2020.
Yeah.
The notice to quit, I'm sorry, Your Honor, I'm going to lose.
It's okay, but just before or after? Was it before or after?
It was well after that.
Well after?
Well after that.
Wait, sorry.
Well after the purchase and well after,
Yes.
and our testimony before the court was that the conditions existed at the time he purchased.
Okay, but
But
were
the
they addressed, did he cure them? Did he fix the sanitary code violations before the notice to quit? That's my question.
I don't believe so, Your Honor, but I'm not, I have to look at the record, I'm sorry.
And is that legally relevant?
No.
Okay.
It's not legally relevant.
Okay.
Yeah, one can withhold rent. The notice to quit can occur at any point.
Yeah.
There may be an issue around eviction in 239-8A. That's not before the court.
Okay, sorry.
No,
Yep.
Sorry. As to the fee issue, so just hearing today that the issue is not overturning the attorney's fee, but rather the court didn't do enough work to analyze the issue of the attorney's fee. I'd ask the court to look at the record, but the court did an analysis of what was the rate that was entitled to the parties, the attorney's fee rate. The second attorney who was on the case was essentially given $0 for the work that she did for all the pretrial work. Then $15,000 further was reduced because of the issues of whether they were fee shifting or not. This is with the discretion of the trial court, who spent many days on trial, many days with motions, many days hearing the same things over and over again. So to the extent the notion is the court didn't do a good enough job at looking at what the result was, what the work was, and what the fee should be, I disagree with that, and I think it's left to the court's discretion. I also want to say that the Colleen case, which was cited, The litigant received $1 in damages and was awarded $170,000, I think it's $170,000 in attorney's fees. And that's clearly not the case here. Beyond that, even in that case, the issue is really whether the attorney's fees were reasonable and whether there should be some kind of reduction. The trial court cited Killeen in its determination of the fees in this case. So, and the court said that it had basically considered all of what are called the Linthicum factors in determining what the fee is. But ultimately, it's left to the trial court's discretion. The question for the court, this court, is whether the trial court abused its discretion in making its determination on fees. I'm going to just deal, in the time I have left, with a couple of the other issues that were raised in the briefs. One is there's an issue about the special verdict form and whether the 18614 instruction was incorrect, the jury verdict form was incorrect by the judge. The jury verdict form is part of the whole jury instruction issue, and the jury instructions were entirely clear that there needed to be negligence in order to find a 18614 violation. I also want to say there's another miscite in the appellant's brief on the fact that they objected to the issue. There was no objection to this issue.
I don't think that's a miscite. I think that's more of a characterization.
I'm sorry. Yes, there's a characterization that my side disagrees with on whether or not there was an objection to the jury verdict form. And the record doesn't have any objection, so therefore it should be waived. And ultimately, I guess the last issue I'd want to address, Your Honors, is the issue of whether the jury appropriately reduced the rent because of the conditions and the ability of the tenant to withhold. BHA versus Hemingway, perhaps the most important case on this point, says that a tenant can withhold. The Berman & Sons case said that, in fact, there's an ability to withhold rent. The landlord in his own proposed jury instruction said the tenant has an obligation to pay rent except upon the landlord's failure to abide by its legal requirements, and then there's an allowance for rent to be waived. So the jury, rather than ignoring the jury instructions, completely followed the jury instructions.
I read some of the jury instructions quickly. I didn't read all of them comprehensively. But I think you yourself maybe characterize it as the jury, at worst, may have skipped a step. And I'm trying to figure out what exactly, in a perfect world, our jury should have done here in reconciling the $1,000 for breach of warranty of habitability and then the rent abatement of whatever it was, $10,910. Like, how, you're supposed to make those two. What's it supposed to look like?
It can look like this, Your Honor. I guess by skipping a step, I mean whether we would have said, oh, when you first went through the warranty of habitability, perhaps it should have been included in the warranty of habitability rather than the reduction of rent.
The abatement. The abatement could have been in the warranty of habitability.
Put in the warranty, I suppose.
But it didn't have to be.
No, not according to the jury instructions, not according to the cases that we've cited. I think, given that my time is almost up, unless there are particular questions that the court has, I'm going to rely on my brief. Thank you very much.
Thank you. Thank you to the parties. The matter is submitted. And at this point, the court will stand in a recess before we return to the remaining cases. We'll now hear the case of Department of Children and Families versus Mother, 25P 710. This is an impounded case. Just reminding the attorneys and the parties.
Good morning, Your Honors. May it please the Court, my name is Attorney Lucas Newbill, and I represent the appellant Mother. Termination of parental rights is the most drastic of steps that a court can take. It is the death knell of all rights of a parent. It's irreversible, and it means that they can no longer see their child without a court order for visitation. They have no right, they have no standing to come to court. They have no more rights. And that wasn't present here. The judge plainly overlooked all of Mother's progress that was in plain sight, and in fact made plain wrong factual determinations in order to get to where she wanted, which was to ensure that the children remain with the foster parents before her retirement a few months after the case. I mean, I can almost flip to any page and point out errors, but you know, on paragraph 319 in the findings of fact, the judge found that she was not engaged in substance abuse and therapy, and she got there. If you look at footnote 12.
I'm sorry, footnote 12 on what page?
This is page 60. It's page 48 of 77 of the findings, but that's in the appendix. It's page 60, and the paragraph is 319. Mother is not currently in any substance use treatment services. That's plainly wrong. And it was submitted, there was a letter from DCF, from her therapist and substance abuse counselor, stating that he provides mental health and substance abuse counseling to Mother. And the judge got there by relying on hearsay. The following sentence, Mr. Hoag told the ICPC worker that he does not provide dual diagnosis services. So the judge has a letter from Mr. Hoag saying that he treats her for mental health and substance use, and the way that she gets to her finding that she's not in any substance use treatment services is by saying, oh, this letter, we're not going to give that any weight because he told the ICPC worker that he doesn't do dual diagnosis.
Can I ask on
Yes,
the
Your Honor.
other, Ms. Hubin, I apologize, technical problem. I haven't been able to look at the trial transcript here. I read Ms. Hubin's report, which was entered as a trial exhibit. Did Ms. Hubin testify at trial?
She did not, Your Honor.
Okay.
Her report was entered in lieu of her testimony.
Right, okay, sorry, okay. But she also gave some information, which was important on substance abuse.
Key.
Yes.
And her report didn't receive a single mention in the 77 pages of findings of fact, except for the fact that Mother completed a substance use evaluation. But that report of Ms. Hubin, well, Ms. Hubin was a former supervisor for DCF and a licensed substance use counselor since the license actually first was created by the state. An excellent witness. And opined that Mother had worked very hard to get to where she was in terms of her sobriety for 5.5 years, right? There's no evidence, and in fact, you know, looking at paragraph 30 in the conclusions of law, where the judge goes through the factors that a court needs to analyze in terminating parental rights, it appears pretty clear that the court is terminating her rights because of concern for domestic violence, right? The court makes mention of a positive for codeine, and actually makes another error in paragraph 295 by stating that Mother denied using codeine at trial. That's flat wrong. She explained at trial that the coding positive was from cough syrup, and that's on 557 of Appendix 16, Mother's Testimony.
On domestic violence.
Yes, Your Honor.
There's no, I assume there's, I think you characterize, everybody characterizes this way. Her relationship with the father was toxic and disastrous for everyone. And I know you're going to say, right, and she stopped. She got out of that toxic relationship. And the last real contact, I think, was at the Whalers Inn 2 years earlier, roughly, and then there was a little bit of multimedia contact after that. Your opponents might say, we don't know how much more contact there was, but put that off to the side for a second. I'm struggling with the sort of the bottom line reality. If they do get back together, and that's speculation, I don't know what I'm supposed to do, but if there's a possibility that they could get back together, that would be disastrous for the children. If she gets, if we unwind this, she gets custody and she then goes back with this fellow, that would be really disastrous for the kids. What are we supposed to do with that? Why aren't we supposed to trust the judge? Why aren't we supposed to defer to the judge's great experience that this is a real possibility?
Well, I think Your Honor got it right in the beginning when you said that would be speculation, right? And that's, I think, maybe what the court did. I think the court really liked where the kids were at, and she found that it would be emotionally traumatizing to remove them from that home, and I think that's why she got where she got and ignored all of the evidence. But with regards to contact with Dad, anytime they were in contact, there was police activity, and that just wasn't the case here.
Wait, sorry, you lost me. That wasn't the case here.
There was no evidence. There was no police contact. There was no social worker report that they had seen each other. And I think
in the last 2 years, you mean?
In the last 2 years, that's correct, Your Honor.
Gotcha.
The last, and I think here's the real evidence, right? In January, she called and left a voicemail and was crying on father's phone in January of 2023.
23.
Right. 3 days later, she took out a restraining order, okay? And there's no evidence that she saw father after that. She moved to Rhode Island. She got a great job. She still has that job. It's a great job. She was flourishing going into trial, and she still is flourishing. But in November, father had started contacting her on social media, right? She emailed him, said, do not contact me. It's in violation of the restraining order. She reported it to the police. She reported it to the social worker, and she reported it to her lawyer. He was arrested for violation of the restraining order. That's not the mom of before, and that is not someone who's going to contact that person again. She had never done that before.
Can I ask you about, unless someone else wants to talk about domestic violence, just shifting to her mental illness. So, can you remind me, I know she was seeing an NP or a nurse practitioner or a psychiatrist, I'm not sure, Dr. White or nurse practitioner White, there were two different references, but who's giving her medication. What is her, the treatment regimen for her mental illness? And yeah, that's it. What's the treatment regimen and is she following it?
So I think there was a prescription bottle that said she needed to take Latuda, I believe it was.
Yeah, that sounds right.
Right, but looking at the medical records, because there was so much records, so much evidence in this case, it was really a product of her working with her provider. I believe it was a psychiatric nurse practitioner, to find the right balance. And going through that conversation, which I provided the citation to in my brief, I don't have it on hand right now, it's reflective of a collaboration with her and her psychiatrist. And the court found that because it was written on her prescription that she had to take it daily instead of what she said was the agreement with her provider as needed, the court found that she wasn't compliant with the doctor's recommendations. But that's not her testimony, and that's not what the records reflect in terms of the collaboration. I mean, it's not in the record that she was to take it as needed from the nurse psychiatrist.
To cut to the chase, is your point that she was in collaboration, all the record evidence is has a psychiatric nurse practitioner, she's seeing that nurse practitioner regularly, she's collaborating, she's following the directions, and there is no evidence that she was not following the directions for her treatment?
Correct. And I think the bigger evidence here is the proof is in the pudding, right? Mother's doing great. She gets her own place after having been homeless when she was with father, staying with her parents, even staying in her car. She gets herself together, begins selling timeshares a year before the end of trial, manages to find an apartment in Rhode Island where she can take the train in and keep that job, and she's just doing very well, right? It's just such a difference between how she was when she was with father and the year and a half leading up into trial. And I think that more than like, let's try to find, where the court could have been right to terminate her parental rights, that's not the standard. The court has to show in its findings that it made a careful deliberation of all of the evidence, and the court did not do that here. I mean, in paragraph 30 of the conclusions of law, unable to detach from father. That's the finding. Unable to manage her finances. That's not accurate. Mother had...
Go ahead. No, go
I mean,
Sorry.
I hear you, and I thought your brief painted a very compelling picture of a person who has overcome some pretty awful struggles and is on a path that seems just so much better and so much healthier. And so that was really, we see a lot of cases like this, and it's always really reassuring to see a case in which the supports and the efforts by the parent seem to be paying off. So I credit your client for all of that. Particularly with the sort of addiction from which she suffers. That is no small task, and she absolutely deserves to be congratulated and appreciated for the strides she's made. I do not read the findings to be as slanted as you represent them to be. And I think when you've pulled out some compelling examples, and obviously you're not going to go through all of them in argument today, but I think overall, for me at least, I see a more balanced approach. In other words, I don't see the judge ignoring the positive things. I see the judge more heavily weighing the significant and long-running history here. And so with that baggy long run-up, my question to you is, how is your argument not, what distinguishes your argument from one that says the judge misweighed the facts? Because the weighing of the facts is really not our department, right? That's the trial judge's department. So how do you get past that?
Well, I think it's plainly wrong to find that domestic violence, that she was unable to detach from father and stop the cycle of domestic violence, because she did, right? And the court noted that she completed the program asked of her at the Independence House, and then discredited or undermined the testimony of the person who runs the Independence House, saying that her testimony was evasive.
Miss Espinoza, right?
Miss Espinoza, that's correct.
Who had worked at the police department, right?
She had worked at the police department prior. That's correct, Your Honor. But she completed the program. She completed SAGE. She completed the Nurturing Mothers.
Isn't SAGE the program where your client maintained that she had done the work, but then she was told she hadn't taken long enough and therefore couldn't take the confirmatory tests, or was that a different program?
I don't believe that was Sage because
Okay.
paragraph 238, the judge found that she completed the
Okay,
program.
I'm misremembering
So, unless,
Can I ask a question about your final issue, because time is short?
yes, Your Honor.
The visitation, so first, I just want to understand very concisely, visitation.
Yes, Your Honor.
The younger child was born in January of 2021.
Right,
And am I correct in understanding that whenever she lost custody, where visitation set up, she was meeting weekly, visiting the child weekly, essentially with a few gaps, but more or less regularly from the point it was set up all the way until trial? Mother visiting weekly with child, both children.
I think
Is
it was.
that accurate?
I think it was switched to biweekly shortly before trial,
Okay.
but
All right.
I don't have an.
That was switched by DCF.
DCF,
And,
correct.
but it's accurate to, I'm not misstating the record to say that for that child's whole life, she was meeting weekly or visiting with that child weekly or biweekly.
That's my understanding, and in fact, the citation in my brief is to the years of observations of visits by the DCF worker, and they are phenomenal.
Right.
And none of that receives any mention by the judge. Your Honors. Thank you.
Good morning. Caitlin Bertino for the Department of Children and Families. Here, the trial court did not abuse its discretion in terminating mother's parental rights and denying to order post-adoption visitation. The uncontested facts here show that the children were subjected to a chaotic and violent household. The court did, as Justice Hershfang had said, acknowledge mother's recent improvements, that she had become more compliant in therapy, she had completed her substance abuse evaluation, she was no longer speaking with father to the department's knowledge. The department and the court was concerned that mother had fully been able to disentangle herself and stop engaging in future domestic violence relationships. Mother had testified that she had been in many domestic violence relationships in the past. She was dating other people after the children were in the department's custody, and she wasn't forthcoming with the department about those men, how often she saw them, who they were. Also in her...
Why is that relevant? I mean, unless there's,
Sure.
if there's domestic violence that somebody knows about, that's definitely relevant. But just dating other men, why is that something she needs to tell them about?
Sure. So the department always had conversations with mother about her ability to take accountability and her ability to, there was a discussion about being able to show red flags, and mother, by hiding or by not being honest about different partners in her life, the department was unable to determine if she was engaging in these relationships, in new relationships, in a healthy way. During her testimony, the court did find that mother was evasive about her substance abuse use, her relationships. There were many times in the record where mother told the department she was no longer with father, and then a few days later, there would be an arrest, or we would find out that she had been living with father.
Can I just, this is a global comment. I think the core of your opponent's argument is time frame. That yes, she had a horrific backstory.
Yes.
She would be the first to talk about the horrific backstory. But we're not talking weeks or months, we're talking years of growth right up before the trial. And it seems like you need to always preface everything with, in the 2-year period, what's the department's position about her years of growth?
Well, the judge always looks at different factors, right? So the growth was one factor, but the judge found that mother hadn't shown that her growth, despite engaging with some services, she hadn't shown appreciable movement in her ability to meet the needs of the child. Mother during her testimony, did not take accountability for the harm that the children had suffered in the past and her behavior in those relationships. And the judge, The judge also considered the bond that the children had, which again is one factor. It's not the only factor, but the judge is allowed to consider the bond that the children have with their pre-adoptive parents.
Wait, no, so, okay,
Sure.
right. On that point, I'm no expert here, but I think there's a two-step analysis, and it's really dangerous to start looking at, and the two steps are parental unfitness and then best interests of the children. And I absolutely applaud the post-adoptive, the pre-adoptive parents here, the great uncle and his partner. They're doing amazing work, and they seem to be bringing great, et cetera, et cetera. They're doing great. I want to be clear about that. But if the question is whether the mother is unfit, I don't think we're supposed to consider the fact that these pre-adoptive parents are doing a spectacular job, right? And mother is, it seems to me, you're saying mother's not being honest and candid about these problems. Mother broke a heroin addiction, and mother broke a vicious cycle of domestic violence years before this termination trial. So, and to this more specific point, her substance abuse growth, Ms. Hubin, the judge seems to ignore what Ms. Hubin is saying. And Ms. Hubin seems to be the biggest expert around in this universe about specifically alcohol. So she keeps testing positive for alcohol. And Ms. Hubin says I learned something new. Yeah, but she's taking Suboxone, she's not getting drunk. Nobody's ever seen her drunk. If that's true, let me really start by saying, do you dispute that scientifically?
Can you repeat which?
Sure, the last piece. Ms. Hubin says that, yes, we are aware that she's testing positive in her urine screens, for alcohol. But that is not a concern because she's taking Suboxone, and therefore, as a matter of science, the alcohol does not affect her. That's why you've never seen her drunk. To me, that was completely news. So my real question is, do you dispute that scientifically?
I don't know the scientific answer to that and whether or not I can dispute that, but I can say that the department had conversations with mother. There's a finding about it that we were concerned that she was still drinking. She had multiple tests for cocaine and marijuana. And again, it goes back to taking accountability. When the conversation about alcohol was brought up at trial and testimony, mother still contended that it was a requirement of her bartending job at a wings restaurant that she had to drink alcohol. She testified that she could stop if she wanted to, and she would if she had the kids' custody back, but she could have stopped drinking alcohol and shown to the department that she was no longer drinking and engaged in that behavior beforehand. Additionally, the cocaine positives, she blamed her own mother, I think it's maternal grandmother, for slipping cocaine into her food. She at one point said someone had put cocaine or alcohol in her food as well. She also blamed father. So going back to, the judge is looking at all of this evidence. The trial judge is the best one to evaluate the different pieces of evidence, to hear the testimony. This was a very long trial. There was a lot of evidence in this trial, and the judge's decision was not an abuse of discretion.
Thank you.
Okay, thank you. If there are no further questions, I'll rest on my brief.
Good morning, Your Honors. My name is Allison Lowe, and I represent the two children who are currently age 6, and the younger child will be 5 years old at the end of this month. The children, Your Honors, are asking this court to affirm the termination decrees, as well as the decision of the trial judge to leave post-adoption visitation to the discretion of the pre-adoptive parents in accordance with the children's best interests. With close attention to the evidence, a diligent and experienced trial judge made 420 detailed findings of fact.
A very wise judge told me once, I don't really focus on the number of factual findings. I'm much more concerned about the accuracy of the findings.
Sure.
And I'm not expressing an opinion yet, but obviously that goes precisely to your opponent's point. He's saying she made a lot of errors.
Well, I think there are two sides to every story. So I would like to maybe pivot and address some of the questions that Your Honors had, primarily of Mother's Counsel. And speaking most immediately, Justice Wood, to your comments about Ms. Hubin's report, which was admitted as exhibit number 90 in the record, I would direct Your Honors to Record Appendix 17, Record Appendix 16, which are the trial transcripts, at pages 1719 to 1720, where the parties specifically stipulated that her report and her CV would come into evidence, but that it specifically was not being used as the opinion of an expert witness. So I think all that you can take from Ms. Hubin's report are perhaps observations that she made of Mother, her accounting of statements that Mother and perhaps collaterals made to her, but any opinions that Ms. Hubin had, regardless of her background, are not entitled to any weight. She was not an expert. My brother made the point that all domestic violence stopped after November of 2023. Now, what we know from Mother's history, she described herself as having experienced domestic violence in all types of relationships in her life, family, friends, and significant others. She made that statement to a court investigator, and you can find that at Record Appendix Volume 2, page 30. Mother told the court investigator that she had been in domestic violence counseling from the age of 10. At the time of trial, she was 32 years old. So she had been going to domestic violence counseling for about 2 decades. And at trial, she testified that she had just signed up for a domestic violence class so that she could be sure to spot the red flags of domestic violence. And I would argue that that does not show appreciable growth by Mother.
So did Independence House do nothing?
Yeah, so Independence House is an agency that's located on Cape Cod. The evidence was that it is not a counseling agency, that it is an educational agency.
Well, isn't that what we're talking about? Educating her about the red flags for domestic violence?
Yes, and so the evidence was that Mother attended either 11 or 14 sessions between the time period January 22 to June of 2023. Those are findings of facts 292 and 293. Accepting that she attended those sessions during that period of time, she was continually to accrue domestic violence incidents. She was continuing to be arrested. She was continuing to be charged with the violations of restraining orders. And most notably, I think, which demonstrates that she had not gained insight into domestic violence, would be the incident at the Whalers Inn, which took place in July of 2022. So that's smack in the middle of this time that she's going to Independence House.
It's 2 years before the trial.
I understand that, Judge. And what I would ask the court to do is to look to the case law on domestic violence. So certainly custody of Vaughn tells us that witnessing domestic violence causes substantial harm to children. Adoption of Elena, which I cite in my brief, stands for the proposition that a long history of abuse shows that children will suffer.
Could I ask you a question about, because time's up?
Yes.
With the panel chief's permission, about visitation.
Yes.
I don't want you to go outside the record, so I'm honestly curious to know how many visits the pre-adoptive parents have permitted, but I don't want you to go outside the record. I guess you're not allowed to answer that. But what's your position on where she visited with, by all accounts, constructively with the kids, and at least the youngest child, virtually his whole life, to then stop? what's the position about leaving it up to the pre-adoptive parents and how often?
Sure. So citing to adoption of Ilona, the law is that a judge may order post-adoption visitation if it is in the children's best interest. However, an order is not compulsory unless it is needed to protect those interests. And the judge has to engage in a balancing of the benefit to the children of post-adoption visitation against the rights of the pre-adoptive or adoptive parents who are entitled to a presumption that they will act in the best interests of their children. And here, the judge credited the testimony of the pre-adoptive father and the pre-adoptive mother that they would continue contact with the children contingent on mother's sobriety and the stability of her mental health. And although she certainly appeared to have been abstinent from heroin since approximately 2016, 2017, her alcohol use, which she testified started after her brother passed away in November of 2021, that went right up to trial, and there were multiple regular screens that were positive for alcohol.
Okay, but so your position, I know time is pretty much up, but your position about this is we think the judge was right to leave it to the discretion of the pre-adopted parents?
Yes, Your Honor, that's
Okay.
my position.
Okay.
And if Your Honors have no other questions, I rest on my brief.
Thank you.
Thank you.
Appreciate the arguments of all parties here. Next case on the list is also partially impounded. It's EB versus JR, 25P163. In this case, the appellant has waived argument. We will hear from the appellee.
Thank you, Judge. Good afternoon, Your Honors. Michael Harrington. I'm here on behalf of EB in this matter. This matter arises, Judge, out of the New Bedford District Court, and it arises about a harassment protection order pursuant to Massachusetts General Laws 258E for protection. Protection for somebody who is in Massachusetts who feels harm, who feels threatened, intimidated, feels that they need some help from the court. So what happened back in December of this year, December of 2024, EB goes to district court, Judge, and she asks for some protection for herself. In context, Judge, EB is a medical doctor. She's further trained as a veterinarian, and she is a veterinarian at the New Bedford Public Park, and inside the park there is a zoo. And in that zoo, Judge, she is the veterinarian for all the animals. And she's a young woman in her early 30s, practicing medicine.
We know the facts. Can I cut to the chase here? Do you agree that that JR is right about the law in her brief, at pages 22 and 23, that under 258E, you have to allege, the judge has to find that she was an intent to cause fear from bodily harm and true threats. So, yeah, intent to commit bodily harm or unlawful physical violence. Is she right about that?
I would disagree, Judge, obviously, Justice Wood on that. The way I read it, Judge, and I'm going to head back to a couple of cases I did cite in my brief, that the direct threats or the imminent physical harm that she's raising right there, you can also look at that or as words or actions that are taken into account in the context in which they arise. And in this case, they would cause the EB, in this particular case, to fear such harm and to know that maybe such harm will be coming in the future.
Wait, sorry, such harm. It sounds like you're actually saying you agree with her, but you have to consider the context. In other words, you do have to threaten harm. It sounds like what you're saying is you have to threaten harm, physical harm, but you can take into account the context, and it could be in the future. Is that what you're saying?
No. What I'm saying is that taken by EB,
From EB's perspective,
From EB's perspective, in the context of what's happening in the surroundings, with yelling and screaming in her face, taking that perspective, the words do not have to be, I'm going to kill you. The words do not have to be, I'm going to punch you.
Okay, does she have to believe that she's subject to physical violence subjectively? Is that what you're
Who
saying?
has to believe that?
Your client, or EB?
EB, yes, she believed that, yes.
Okay, so is that necessary? Does she have to, in other words, let's just, aside from intent, your argument is that EB needs to subjectively believe that she is being threatened with physical harm?
She was, yes.
But that's what she believes?
Yes.
Okay.
Correct.
Well,
Okay.
and also, a reasonable person in that position would believe that.
Correct. And correct, in the context of what was happening, yes. As a reasonable person or as herself would have to believe that she was fearing for harm for herself, yes.
Okay, now what do you do? Sorry, I apologize.
Can you explain that context then?
In the context, so at a confined area in the park, in the zoo, where all this happens, is it's outdoors and then indoors of the area. When someone is there every single day, as JR said that she would testify before that she would go to the zoo almost every day from 2010 to 2014, and then from 2014 again almost every other day. And then after the federal court trial, she testified that she went every single day to the zoo. So she would appear every single day in a certain part of the area, in a certain part of this, I think the park is a couple hundred acres, in a certain part of a little area where EB is, JR would appear. JR would be there and then comment about the care of these elephants, the care of Ruth the elephants. Not only would she start to comment, she would verbally and abusively get in the face of EB consistently and always about the care that EB was providing to the elephants. So now we have a context of every single day for years of a person showing up at a zoo with the facts that we know from the federal court cases, that her testimony was she's emotionally involved in these elephants. She's emotionally involved.
She's an advocate, right? She's an advocate for them.
More than an advocate, much more than an advocate. It's almost an emotional attachment to Ruth the elephant.
Well, Ruth is no longer with us. I mean,
Correct.
I think, I'm not sure it's helpful to argue about the contours of advocacy, but I think one of the things that concerns me a little bit about the argument you're making is, I think, and tell me if you disagree, that what we look at when we try to figure out whether your client made out the elements of required for a 258E order is what is in the affidavit. So she does say generally that JR shows up all the time, but some of the gloss you're giving us today is not in there. So the affidavit articulates 4 different
Correct.
things, right? And one of those is a written complaint to the board about a veterinary license, which, are you contending that that is something we should consider as a true threat?
I would put that into the context of what is the whole events that are going on with this, Your Honor, Justice. And I know it's a kind of I don't want to gloss over that, but what I'm saying to you is this, that when it's been going on for a period of years of a person every single day at the zoo, and after the federal court case came down and she didn't do well, she ramped up her intensity against EB. So when you start adding things together, the goal is to get EB out. The goal is to get her out because she is supposedly not taking care of these animals.
Right, but it seems like the goal, from what we can gather from the affidavit and your client's testimony at the hearing, she just wants to get her out very specifically by somehow getting her veterinary license, get her fired, get her veterinary license revoked, and get her to stop treating the animals. That's not physical violence. Do you agree that if that's what she's really trying to do, if that's her agenda, then that's not a violation of 258E?
No, because
no, you don't agree.
That's just, I don't agree with that. What you're saying would be the agenda to to say, okay, we're going to say that this one letter taken by itself is, sorry, my voice is gone. I was yelling at the Patriots last night. I apologize.
I'm sure they appreciate
They
it.
can't hear you, but
Sorry. So back to the seriousness. So on that one instance with the letter to the board, what I believe to be, what should say, what was given to the court in district court in New Bedford was that was just one little step in the process of getting to EB for fear. As she testified, she put in her affidavit that she thought that the intensity was ramping up to say that I'm afraid for myself now. I don't know if this lady has a gun, or I should say a weapon. There's no security at the court. There's no security where I am. The intensity of her trying to get at me, maybe because of the elephants, obviously because of the elephants, she's using me basically as a conduit for her rage. So she goes after the letter is one thing, which is false, about her taking care of the animals. Federal court already said she did a good job and she did everything she's supposed to do. And Judge Coyne had all that information in front of her. Everything was perfect what she did with the animals. So she raises again a falsehood about EB to the veterinarians, so as another little tweak in her to intimidate her, to say, listen, I don't want to be here anymore. I'm afraid of my job. I'm afraid of getting hurt. I'm a young person here. So what happens is when the court goes down the questioning during the hearings as to what was the fear and what was she afraid of, she said she was afraid of her safety. She was afraid of getting hurt because she didn't know what this lady could do after raising it from yelling at her to getting in her face, chasing her, and screaming her.
do you think, so there's a Supreme Court case, Virginia v. Black, which she cites, 2003, a true threat must communicate a serious expression of an intent, and this is an intent of the defendant, to commit an act of unlawful violence. So it's not just your client's subjective impression, accepting that she wrote in her affidavit and testified, I don't know what she's capable of, I don't know, we have no security here, I don't know if she's got a gun, I'm worried that she might shoot me. I mean, taking that at face value, that seems like a subjective fear of harm. I'll give you that. But I think, does the judge also have to find preponderance of the evidence that JR had an intent to commit an act of unlawful violence, or a threat, an intent to convey a threat of unlawful violence? Did that happen here? By
just using the word true threat, the way I interpret it, the way I'm asking the court to look at this is on one of the recent cases that I cited, DC versus KD from June 16th of this year. The court looks at different things of fear and intimidation, and in that case, the defendant argues when an act is only speech, then the act must be either a true threat or fighting words, citing O'Brien. But then they go through to say, this court goes on to say, a true threat does not require an explicit statement of an intention to harm the victim, as long as the circumstances support the victim's fearful or apprehensive response.
Right, and we have any number of unpublished cases that say similar things. I think the question that I have in my mind, which may also be the question Justice Wood has in his mind, is absolutely taking EB's words as true. EB is afraid, and is afraid of sort of up to and including physical violence, but looking objectively at the harm that is being threatened, what is there that the judge had in front of the judge to say there is an objectively reasonable fear of physical violence? Because this covers physical violence. So even if there is just a horrible campaign underway to try to rob this young person of a job and a hard-fought license and all of that, that's not a true threat under the statute.
I agree with that. However, Judge, I think that, Your Justice, I believe that the facts and circumstances before Judge Coyne were a little bit, and also in the record, just a little bit different than if you look at and you're saying as an objective person, in the reasonable standard of what's going on with this, if you add up things that even sometimes people don't know, like different cases where a person puts the tracker on a car, or a person, in different cases, or a person is taking pictures of a person, thousands of pictures, they don't even know they're taking pictures of them. But that would raise a fear in a person. That raises fear in a person. Take that to the next level when you have a person at your job every single day staring you down with an intent to say, hey, listen, you are a bad person because you are cruel and inhumane and you are the person to these animals. Take that to the next step where she goes to the board and says that she's not qualified. Of course, that's wrong. Take it to the next step, Judge, that she gets into her face and she starts screaming at her, and then she starts chasing her on 2 occasions. So I think that as an objective part for the discretion of Judge Coyne down in the district court, when you hear all this going on, Judge Antonio heard it first, then Judge Coyne heard it second. To hear all this was going on, as an objective person, as a reasonable person, the judge taking into the credibility of the 2 people before her could obviously find, Judge, that this young lady, E.B., was in fear of imminent harm by this woman. Not just because she didn't threaten it and say, I'm going to do these things to you, but by the whole atmosphere and the entire circumstances. I think that's where this case falls, Judge. It's a little bit different just because of that. Thank you. Do you have any further questions? Thank you.
Thank you very much.
Sorry again with my voice. I apologize.
No worries. And so at this point, we move to the next case, Stephen Franzosa versus Neil Rossman, 25P282.
May I?
Yes, please proceed.
Thank you. May it please the court, I'm Mary Ellen Manning. Happy New Year. I represent Stephen Franzosa. He's a firefighter with the city of Peabody. He retired. He was a professional firefighter for over 30 years. This is a legal malpractice case in which the trial court ruled that an aborted settlement agreement should be enforced, and we seek reversal of that. There were 3 parties to this agreement. One was Stephen Franzosa, the appellant. He was represented by an attorney who was a placeholder attorney during the period of time that I was disqualified from the case because I had been sued.
Well, he wasn't a placeholder. I mean, he was the attorney. And he had
That's correct.
More than that. He had, and there was no indication that he was going to be moved out until the claim against you was dismissed. So to characterize him as a placeholder seems wrong.
Thank you, Your Honor. His limited appearance did say that when I was reinstated to the case, he would no longer be the attorney. And I was trying to distinguish, not to minimize his role, but to distinguish him from my role, which was as the prior attorney. So I apologize. I didn't mean to demean him. I didn't mean to demean him in any way. And he was represented by Attorney Holzberg at that time. I was the third-party defendant during those negotiations. And the appellees were the divorce attorneys.
We know the facts and the procedural history. So the bottom line to me is whether a contract, an agreement was formed.
Correct.
And we got the evidentiary hearing transcript. I reviewed that carefully.
Thank you.
And it seems that very clear to me that there was an agreement that Attorney Holzberg had the authority to reach the agreement and that everybody agreed. The only thing that changed was that after everybody had agreed, while you were on vacation, the a court dismissed the charges against, the civil claims against you. And the judge kept asking you over and over again, why does that make any difference? And I didn't see an answer that made any sense to me. So what's the answer?
The answer to that particular question is that
Changed. Why did the charges, the civil claim against you being dismissed, change the agreement that had been reached?
there was no agreement that had been reached.
Let's assume in my question that I believe there was an agreement that had been reached. And the only thing that changed, there was a meeting of the minds in contract terms. Assume for the sake of this argument, my question, that that's the case, I believe to be the case. What changed to undo that agreement, that meeting of the minds, based solely on the case being dismissed against you?
The case being dismissed against me allowed Mr. Franzosa to have me back as his attorney and proceed with what we had.
But the negotiation was precise. The terms of the negotiation were laid out, and the evidentiary hearing made it clear that the goal was that the terms that he wanted, were that no liability against any of you, no fees against any of you, including you. So you got that. He got that. He wanted you to not face any downside, and he got that.
May I, Your Honor, on that? Everything you're saying presupposes that that Attorney Holzberg actually conversed with the client. And he testified that he did not. He did not discuss.
He also testified that he had authority to negotiate.
That's correct, Your Honor. He
client
did.
had delegated to him the authority to settle this matter.
In the cases, Precious v. O'Rourke and other cases, Your Honor, it distinguishes between the general authority that a lawyer has to be able to settle in general with the specific authority that a lawyer has to settle under the terms that are at present, that are presented in a particular case. And I suggest to you, Your Honor, that there was that it's the appellee's burden of proof to show that Mr. Holzberg, Attorney Holzberg, had that authority. And they did not present any evidence at all of the type that is required to show that he did have that authority. In fact, Your Honor, there are cases where lawyers have come forward to say, I did have the authority. I had the authority to settle. And the court said, no, you did not have the authority to settle. For example, in Newton Center v. Jaffe, the client had died, and the attorney presented himself as having authority to settle and did settle the case, but that was overturned because once the client had died, there was no more authority.
So is there any evidence in this case, as in that one, to show that there was no evidence, or no authority, or that the client contradicted what the attorney did?
The client did not testify at this hearing. The court said that if the client testified, that they would that would implicate attorney-client privilege, and while the court relied solely on the testimony of Attorney Holzberg, and while Attorney Holzberg did say, I did have authority to settle, he also said, I never showed this agreement to my client. I never went over it with him. I never communicated with him. Why? Because he was waiting till the end. There were other parties involved. I was involved, the appellees were involved, and he was going to wait to the end to make sure that it was all ironed out, and then he would be at the end and decide whether or not he agreed with those terms, and he'd go over it with his client. That's what was developed at trial. Yes, Your Honor.
I'm just confused, having read the hearing transcript, about what your role was on October 26th.
Right.
And I'm going to tell you what I think is true, and if I'm wrong, please correct me. I think at that point you were still a party to the lawsuit.
That's correct.
And at that point you did not represent Mr. Franzosa.
Correct, and I had no communication with him.
And Attorney Holzberg did not represent you?
He did not.
So you were a pro se, which is a weird thing to say about a lawyer, but you know what I mean. You
Yes.
were a pro se party
Correct.
to the lawsuit.
That's correct.
So I am confused then about why it was that Attorney Holzberg would need to consult with you before giving, and putting aside the question of his authority from the client,
Right.
assume for the purpose of this question that he
Right.
had authority. If he had authority for Mr. Franzosa to settle on the terms that were proposed in Ms. Kim's last email,
If he did, yes.
why is it that the subsequent change of your status, or actually, why is it that your present status at that moment on October 26th has anything to do with Attorney Holzberg's authority at that moment?
I don't think Attorney Holzberg was waiting to consult with me. I think he was waiting, as a practical matter, why get himself involved in two other parties that are working on the agreement? Why not just wait till the end? And
What do you mean by two other parties?
well, I was working on the agreement with the appellees,
For you?
for me, and he wasn't going to bother looking at it until after it had been ironed out by the both of us, and then he would look at it. That was his testimony.
No, sorry, I'm just not reading it that way. I'm looking at page 66 of the transcript, and this is just quoting Attorney Kim's affidavit. Attorney Holzberg said the draft stipulation of dismissal was exactly what plaintiff was looking for, that's Mr. Franzosa, to settle all claims in the matter, and that he and plaintiff would sign it. Did you say that? Yes. So, sorry, they weren't waiting. He represented, they were good. He had consulted with his client, and they were willing to sign it.
He also said that there would be no signing or review by his client until after I got returned from vacation and had looked at the final agreement and agreed it was correct. That's what he said.
But that's sort of at the nub of the question I asked earlier about
Right.
your status. What did you have to do at all with that agreement at that point? By that point, I mean on
Right.
October 26th.
Well, on October 25th, I had made my revisions, and the series of emails, I think it begins around 138. It's repeated in a few different places in the appendix. But the series of emails that were on October 25th, I had made some revisions, and Attorney Kim, which is the appellant's attorney, appellee's attorney, got back to me and said that she was sending over an agreement to those changes. And then she withdrew that. And then I said, it was around this time that I said, look, I'm getting on a plane. I can't look at any of this right now. And then she went back again and made a revision. And then I never got back to her again. At that point, it was the 26th. I had flown, and on the 30th, 25th, I had flown. 26th, the last thing that Attorney Holzberg heard from me was that I had gotten on a plane. And he says, listen, we're not going to do anything until she gets back. I mean, she's on vacation.
So do you disagree with the judge's determination that there were no substantive changes that you had? That you identified no substantive changes?
No, I don't agree with that.
Substantive.
Yeah, they had a provision in there that said that they wanted it recognized that no monies had exchanged hands between us and the appellants. And I said, well, if you're going to put that provision in, then I'm going to put in the provision that no money had exchanged hands between me and the appellants.
Was that part of this hearing?
Yes.
Okay, can you point that to me?
Sure, I believe it's on page 138 through, like, say, 135 of the appendix. It shows the series of 138 says, just say 143 of the appendix?
This is the email exchange, right, with Attorney Kim?
Correct.
Right, and she accepted all your proposed changes.
But then she reneged.
No, so sorry,
then-
when you say reneged, I think you mean she changed one word, which the judge characterized as de minimis.
Well, that's...
And are we talking about the same thing?
No, we're talking about something, I don't mean to yell into the microphone, I'm sorry. We're talking about something else. We're talking about when I made my changes, she got back to me and said, okay, it's ready to sign. Then she said, oh no, wait a minute, I have more changes to make. And that was a big sentence that it wasn't one word. It was a series of, a sentence that said something about how both sides were going to, both sides agreed that neither side had, paid the others. You know, the issue here is whether or not, to my mind, is whether or not there was a present intent to settle. And Mr. Franzosa was never given that opportunity to give a present, to express his present intent. In all the cases that the other side cites where an uncompleted agreement went to be enforced, they all were either reported to the court, they had a course of dealing prior, they had changed their position in some way where they canceled a flight or they canceled mediation. None of these elements are in play here. This is a series of exchanges back and forth that never got completed, and the defendant, Mr. Franzosa, the appellant, never communicated to the other side or through the other side that he had agreed to this provision. He didn't even communicate to his own client that. There is no evidence on the record that Mr. Franzosa told him. Mr. Attorney Holzberg said that's what that he had the authority, but he also said he never talked to his client.
Because he already had the authority. He knew what the objective was, and that was achieved through the settlement agreement, right?
That is what he said, but he never, there is no manifestation that they showed or that was established. In fact, the opposite was shown, that Mr. Franzosa had actually given any authority to Attorney Holzberg to settle under these terms up through the 26th. There just is no evidence of that at all. And it's their burden of proof. Since it's a question of, there's no other facts that need to be developed to determine whether or not there was authority here, we say that this is a question of law at this point, and that's not something that can be waived. They raised whether or not we waive the argument whether Attorney Holzberg actually had agency or authority. And even though it was argued in my original paperwork and was just, thoroughly fleshed out at the hearing, and of course the court did conclude that that Mr. Holzberg had authority, that was based solely on Mr. Holzberg saying, I had authority.
But how else would the other side present evidence of that?
The law says that they have that they assume authority at their own peril, and they were on notice that he really didn't have authority because he told them that he hadn't talked to his client yet, and he wasn't going to talk to his client until after it was finalized. And I got back from vacation, and he did not believe, and he testified to this, that the agreement was finalized. He testified that that agreement was not final, that it was still in flux. That's what he testified to.
Thank you.
Thank you very much. I appreciate the extra time.
Good morning, good afternoon, Your Honors. This actually, the case is quite simple. The analysis starts with the order from the court
which is a part of the appendix to one of our two briefs, which says plaintiff's attorney at the time of the settlement had authority to settle the case as of the last settlement proposal and admitted on the stand during the hearing that the stipulation was exactly what the plaintiff was looking for to settle the case. I mean, if you interpret that, and by the way, there's a clear error standard, and it's the plaintiff has not established, or no one has established, that the judge made a clear error. Attorney Holzberg knew that that was what the plaintiff was looking for because he talked to the plaintiff. The plaintiff told him. I mean, this case really boils down to the October 25th emails where Attorney Manning sent a revision to Attorney Kim. Attorney Kim accepted those revisions on that same day, and the email is in the appendix. And then there was the conversation on October 26th where Attorney Holzberg said, this is what my client was looking for, exactly what he was looking for. The only thing that changed was October 30th. And the fact that the trial court granted Attorney Manning's motion to reconsider with respect to a motion to dismiss. There are a few certainties in life, very, very few certainties. But I can tell you one thing is for certain. If the court had never, ever reversed the ruling on the motion to dismiss, we wouldn't be here. This is what this is all about. That was the impetus for this, because Attorney Manning at that point can jump back in the ring. But by that time, it was too late. There was an agreement between Attorney Kim and Attorney Holzberg. They had the agreement, again, what changed after October 26th? Nothing except the decision on the motion to dismiss. And that's not a sufficient reason to say there wasn't an agreement in the first instance. There was an agreement in the first instance. There was clearly an agreement in the first instance. And frankly, I don't, why Attorney Manning even injected herself into the stipulation of dismissal back before 1025. I mean, it was really between...
But that, we don't have to think about that to get to where we're going.
I have a question about her very first point in her brief, page 8 of her brief. October 24th, Attorney Kim sends an email. We would require original signatures, including from Mr. Franzosa. So what's your answer to that argument that, look, your side introduced this requirement of signatures?
I mean, it's a ministerial requirement. It doesn't go to the substance. And Attorney Manning cited an SJC case, I think it's the Tobin case, where it was an offer to purchase real estate, and a requirement was a signature on the offer. There was no signature on the offer, and the SJC said the offer is still enforceable contract. What possible difference could that make, what signature? That was a ministerial, technical thing. That didn't go to the substance of the agreement. The substance of the agreement was this case is dismissed with prejudice, without cost, each side waiving his or her rights of appeal. That's the substance of the agreement. Everything else was formalities. It didn't go to the essence of the agreement. And again, the case law is clear. You don't need a signature in order to do a deal if there was a meeting of the minds and there's a contract. And again, the Tobin case, which Attorney Manning cites incorrectly, supports the proposition, which I just stated. Again, when you look at all this and, you just look at the emails and you look at, there's no explanation for what changed after 1030. It's clear they had a deal. Attorney Holzberg and Attorney Kim had a deal, and that deal should be enforced. That's the only thing I have to say, Your Honors.
Okay. Thank you.
Okay, thank you.
Appreciate the arguments. The matter is submitted. And that does conclude the sitting of today's session. Thank you all.